2 p.m. My lord, the difficulty is, my lord, Mr. Sain, my lord, has to address the Honorable Division Bench at court number 11, my lord, from 2 p.m. My lord. So he has requested if the matter could be, my lord, accommodated in the first half, subject to your lordship's convenience.
Mention at that time, it would be reposted.
So grateful, your lordship.
Okay. Take the mic.
My lord, serial number 230 of the monthly list, my lord, this matter was appearing under upgraded matters and it was taken up on, my lord, Monday, whereas, my lord, the other side's senior was not available, for which your lordship directed the matter to appear on the next date, Tuesday. My lord, it was not in the list yesterday. Your lordship kindly
Follow the list, it will be your answer, you will get your answer. Okay, follow the list. Only Monday and Tuesday, the updated matter will be taken up for hearing. Okay.
My lord, it was directed,
Monday.
but my lord, since it has not appeared and your lordship will, my lord.
It will appear. Don't worry, it will appear. Okay, next. He call the list.
Item number 1.
The IP for the state response.
Here on behalf of the petitioner, this is that matter. The lordship recalls Mr. Muralidharan was appearing, my lord. It was leading
Sir, we
this
are
matter.
to trace out
Lord,
the deeds.
Oh, yes.
So
yes,
he, my lord, my learned friend was supposed to take instruction whether those deeds are
yes.
traceable
Oh,
or
that
not.
matter. Yes, yes. Yes.
And my lord, I'm told Mr. Muralidharan is appearing online, my lord. I can't see, my lord. এটা একটু on করুন না.
My lord, I am also appearing on behalf of the petitioner. Dr.
Yes.
Muralidhar is also leading me in this matter along with Mr. Ghoshal. My lord, if the state, my lord, informs us, my lord, what their stance is today, my lord, we can then take the matter forward, my lord. If the deed has been found, my lord, my instructions are we are ready and willing to pay the stamp duty without prejudice to our rights and contentions in the
But
petition.
that was not agreed upon, my lord. My lord will remember initially he said that without prejudice, the deeds, he wanted to obtain the deed without prejudice by paying this amount. Subsequently, Mr. Muralidharan has stated before lordship that he will even not press this application. My lord, I am agreeable to hand over the deeds on, my lord, if he does not press this application, not otherwise, because of two reasons, my lord. My lord will know this appeal, this writ petition is not maintainable. The order impugned is an appealable order under 47(5), subsection 5. That is there. And also, my lord, the relief, this interim relief will tantamount to final relief. On these two scores, my lord, I'll oppose the prayer for handing over of the deed at this juncture if he presses the writ petition otherwise. My learned senior friend has, on the previous occasion, I will kindly remember, initially he said he'll not, without prejudice, he wants to make this payment. Then he agreed to the fact, my lord, when I opposed, my lord, he did not.
Because we have that wasn't the intention of our client, my lord. It's very clear. We have submitted a deed, my lord, for completing a registration process in the year 2003. That deed, my lord, was taken by the registration authority, kept, my lord, for several years. In 2023, they demanded that you have to pay in terms of 2023 market rate. That was, my lord, the contention raised before this, my lord, Honorable Court, under Article 226. And, my lord, to this, there is already, my lord, an order passed by Justice Shubhashachi Bhattacharya, where, my lord, his lordship has allowed that you cannot claim in terms of, my lord, the market rate in 2023.
In this matter?
No, separate matter. But legal principle is same. Might be separate. In the factual backdrop, it is absolutely same. Then if I pay, my lord, and I say that I don't want to press my writ petition, what happens to my cause of action? Then I'm foregoing my cause of action for the entire year.
Absolutely. That is what was submitted by your learned senior friend.
And I don't understand something, my lord. Even if I pay without prejudice, how can, my lord, the writ petition be decided on that score? My lord, I say that I'm going to deposit that amount with the registrar. It is, my lord, by way of security. Nothing else, nothing more. I am showing my bona fide. I want those deeds, my lord. I have to use it for another proceeding. I want those deeds.
My lord, this is a new submission, my lord. My lord, I will kindly...
Absolutely not a new submission.
Please allow me to submit. When you have submitted, I did not interfere. My lord will kindly hear Mr. Muralidharan. He has submitted on the previous occasion. My lord will kindly remember that he will not press if the deeds are available, otherwise he will not press the writ petition. My lord will kindly hear him. A new stand is taken by his learned junior today. I cannot.
No. This is absolutely not a new stand.
We have the records of the
Very well.
proceedings today. Thankfully, I can show it to the court what was submitted by learned
Very well.
senior friend.
Show it. Show it.
My lord, today what I am seeking, my lord, is in the nature of interim relief before your lordship.
That amounts to final relief.
No prejudice. No.
Well,
Final
then my
relief
lord
will be
will
if I
decide
succeed in the
the
writ petition. I
maintainability
am
of
today
the writ
agreeable
petition
to pay
itself.
what the state has
Is there
demanded. No
a
prejudice can be
fictitious-
caused to the state if this prayer of mine is allowed.
Then I take the point of maintainability at
Let
the
the
outset.
state
My
get
lord
the
will
stamp
decide
duty
that.
which they are demanding. Let it finally be decided in the writ petition whether
I
this calculation of the stamp duty was correct or not on the part of the state authorities.
I'll take the question of maintainability. That has to be decided first, sir.
Yes, of course. The question of maintainability can also be raised. No difficulty there. But he cannot withhold my deed, which I've been entitled to for so many years, today on the pretext that the maintainability of the writ petition has to be decided.
I am unable to understand why a state is imposing another condition that they have to withdraw the petition.
Because it was submitted. It's not.
No,
it
issue needs to be determined.
True.
Whether in respect of such sort of pending deed, it is called pending deed.
Yes.
Look at pending
Absolutely.
deed.
I'm grateful to my.
Although this system has now been discontinued. Initially, the person who presented the deed deposit a certain amount of money, making a request to you, you assess the amount, I shall deposit the entire amount, and then I shall take back, I shall receive the deed.
My lord.
Now, the deed, actually the valuation would be on the date of presentation of the deed. It is a common understanding says so. On the presentation. Now, if keeping the said deed or assessment pending for years, now suddenly after 10 years or 10 years,
Your lordship will decide
the assessment is done, and on the date, as per the market value on the date of assessment, any person is forced to pay, whether it would be reasonable on the part of the state.
This is the abrupt idea that the court is having. But my lord will kindly look into the provisions and my lord will decide the issue. This issue has to be decided by today, my lord. Why am I opposing this?
Yes, you are opposing that there is an alternative remedy. Only on the ground of alternative remedy. That due to alternative remedy, writ petition is not maintainable. Okay. You will say that at the outset that you are raising the issue of maintainability on the ground of existence of alternative remedy. It is your stand. It is the stand of the state. But since he is urgent need of the deed, he is agreed to, subject to the determination, whether he will.
I bow down to your lordship. I bow down to your lordship. My lord, at the same time, my lord will appreciate we are creature of instructions. My lord, we have to follow the instructions of our client. Lord, I communicated to my client that the petitioner, Mr. Muralidharan, has submitted on the previous occasion that he, to the extent he will withdraw this petition.
No. That wasn't the submission.
I read.
Greatest of respect to my learned friend, that wasn't the submission.
I was trying to find out the submission made by learned senior advocate Muralidharan, which has been recorded in the order dated 16 July 2025. I can read out to you for you.
Your lordship
We further submit without prejudice to the right and contention raised in the present petition. The petitioners are willing to deposit the amounts indicated in the assessment order dated such and such, subject to the condition that upon acceptance of such amount, concerned respondents shall return the original sale deed to the petitioner. I think that was a good proposal.
If that is, my lord, your lordship is of the opinion that it should be allowed, but we will allow it to keep the question of maintainability open.
Yes, you deposit the amount, and the issue raised by you will be determined whether the state, it is not for a particular deed, it in respect of in all deeds. So the state will be able to demand the market value on the date of assessment or on the date of presentation of the
My
deed.
lord.
It is the issue to be determined
My lord.
in this
My lord.
petition.
My lord.
So far, my perception.
We bow down. We
So
bow down.
subject to correction, there is a
I think you both of you obey the order
My lord.
passed on that day.
We will.
You deposit the amount without prejudice to a rights and
Absolutely.
condition.
absolute,
However, the issue of maintainability petition will also be open.
absolutely.
Every the issue which has been raised by both of you shall be addressed.
Very well.
We'll do that.
And
Okay.
within 7 days, my lord, they shall hand over the deed to us.
No,
Somebody
okay.
will-
The date of the deposit.
Okay, since they have located the deed,
Yes.
so there cannot be any impediment to hand over the deed upon acceptance.
And let it be recorded, my lord. Let the statement be recorded that they have found out the deed, my lord.
Stop. Ashwin.
Kindly, my lord, also fix a time frame within which this exercise has to be completed. And thereafter, my lord can keep the writ petition for final hearing any date as per your lordship's convenience.
Okay, acha. The petitioner presented two separate sale deeds pertaining to TWO commercial places. Upon payment of certain amounts towards stamp duties and registration fees. Following the completion of registration process, IGR were also issued in favor of the petitioner. However, the original sale deed had not been returned to the petitioner on the ground of payment of inadequate stamp duties. ঠিক আছে? So, on 16th July 2025, when the matter was taken up for hearing, Mr. Muralidharan Lane, senior advocate representing the petitioner, submitted that the petitioners were in urgent need of those two original sale deeds, and he expressed willingness to deposit the amounts indicated in the assessment order dated 7th August 2021 without prejudice to the rights and contention raised in the present petition, subject to the condition that upon acceptance of such amounts, concerned respondent shall return the original deeds to the petitioner. Stop. Mr. Chatterjee, learned advocate representing the petitioner, representing the state respondent, paid for a short accommodation to take instruction with regard to the submission advance on behalf of the petitioner. Stop. Today, Mr. Chatterjee submits that
On instruction.
on instruction that the sale deeds have been located. However, this has been located. Stop. He submits that this writ petition is not maintainable due to existence of alternative remedy, existence of efficacious alternative remedy. He submits that the assessment order is applicable in view of subsection 5 of section 47 of the Registration Act.
Indian Stamp Act.
Stop.
Yes, stamp.
However, ultimately, during the course of hearing, the party reached to he submits that the issue of maintainability of this petition be kept open to be decided at the time of final hearing of the writ petition. Stop. having heard the learned advocate appearing for the respective parties and upon having regard to the submission made on behalf of the respective parties and fact and circumstances of this case, ঠিক আছে? I direct the concerned respondent means
Milord, 4, respondent number 4. Milord.
4. Respondent number 4 to return the original sale deeds. 5 number বলতে পারলে ভালো। Do you know 5 number?
GR নাম্বারটা বলো।
আচ্ছা 5 number such and such dated such and such, আমি এটা রেখে দিন, আমি খুঁজছি, খুঁজে বলে দিচ্ছি, বুঝতে পেরেছেন? You find out, you learned junior, you find out and give it to my officer. Yes. আচ্ছা upon acceptance of the amount indicated in the assessment order dated 7th August 2021.
And compliance of necessary formalities, if any. There might be.
And also upon compliance of necessary formalities.
Why are you opposing for anything?
Such acceptance of this deed shall be without prejudice to the rights and contention. Without prejudice. Such right and raised by the petitioner in the present writ petition. Stop.
And Milord,
those deeds, those 2 sale deeds shall be returned to the petitioner within 7 days from the date of deposition of the amount and the amount mentioned in the assessment order.
7 days, my lord, kindly give it, make it 2 weeks, my lord.
no, Milord, there's some kind of urgency.
You have
to
There is
scan-
urgency.
My lord, we have to scan it, prepare it, stamp it, give it. If it,
within 10 days.
What were they
Within
doing
10
for
days.
several
Within
years?
10 days from the date of deposition of the amount mentioned in the assessment order. ঠিক আছে, stop. আচ্ছা, list the matter for final hearing.
no, my lord, there is no direction of affidavit. My lord will kindly direct filing of affidavit in oppositions.
আচ্ছা, Mr. Chatterjee, press for leave to file affidavit in opposition to the writ petition. Stop. In view thereof, the respondents are directed to file affidavit in opposition to the writ petition within a period of
I will kindly give it. Now there is no urgency.
3 weeks.
At least 4 weeks, my lord.
Court has urgency to dispose of expeditious.
My lord, your lordship, I know, my lordship,
You have no urgency.
any
But
legal,
court has urgency
any
that
legal,
you,
any
you do work
legal point your lordship gets, your
and
lordship
assist
is
the
always
court to
desire.
dispose of the matter
We
expeditiously.
will. 4 weeks, my lord.
Acha, 4 weeks. Reply thereto, if any, be filed within
2 weeks. 2 weeks.
within 2 weeks. List the matter for final hearing 6 weeks hence.
We are grateful for that.
Most grateful, my lord.
Yes, yes,
Grateful.
yes. Either
Milord, only
is Mr. Muridhan is appearing through VC.
no, I couldn't find him, Milord.
So whether his name will be recorded.
Let it be recorded, Milord, since
Appearing. There. Oh. Tell me.
and Milord, only one thing, Milord, liberty to mention, Milord, for early hearing, Milord. After
6 weeks.
after 6 weeks.
Where is Mr. তাহলে ওটা কেটে দিন, এই 6 weeks টা কেটে দিন। Liberty is granted to the parties are at liberty to mention this matter for enlistment after expiry of the period specified towards exchange of affidavits.
Great. Great.
Yes. দেখুন
Item number 2.
Now we are
I am happy with the
Your
petitioner.
Lordship's judgment. Now we are so far driving license is concerned. It should be
oh,
I am happy petitioner. Respond number 2, my lord. LIC
affidavit in opposition.
opposition.
My lord, forget it, opposition. But it's a innocuous pair. My lord, I took a loan from the LIC housing. That, my lord, loan has been paid in the year of 2016. My lord, there is a tripartite agreement. So far, my lord, LIC housing, me and my lord, promoter. My lord, loan was paid. My lord, that document, registered deed, was not, my lord, returned to my client. My lord, I made a representation, so many representations. Now understand that that original deed somehow lost. My lord, only one direction may be given to the, my lord, respondent LIC housing. My lord, to provide me a certified copy of the deed, or to my lord, register made party and my lord, direction may be given to the registrar to provide me duplicate deed.
Duplicate deed cannot
That
be
means
given if
certified
it is
copy.
lost.
That means certified copy. From the
Certified copy, you also can
no, because my lord,
Withdraw.
I could not, my lord, sell it because of the, my lord, everybody can, my lord, try to, my lord, get the original copy without authenticity, my lord. If your lordship, my lord, passes an order to, my lord, LIC, my lord, give the certified copy of the deed or the registrar. My lord, I can show it to a party that original deed. So can I sell my property also. This is my content. It's a innocuous paper.
you are
Where
appearing for the
LIC
LIC.
also-
LIC, my lord, this is the, my lord, the loan, my lord, 7 lakhs. My lord, the under construction flat. My lord, partly first, my lord, the final payment was made at the time of registration.
At the
My lord,
time of registration.
registration. My lord,
Registration of
registration of sale deed. And my lord, partly payment and construction was made. And there are the last installment not taken, my lord, in between the promoter and my lord petitioner registered and no handover this
Then, my lord, I
idea
can go into the
not
deed.
in it.
My lord,
My lord, in this basement to the my lord the dispute, my lord,
okay, as on date,
Man.
they have paid all the loan.
all the my lord these the good customers, my lord, on the diesel.
You disburse the loan or release the loan, keeping the sale deed in your possession, in your custody.
No, my lord.
Now it is your duty to return the sale deed
Yes.
to the person
there is a
My
RBI
lord,
regulation.
my lord, this is
after repayment of the loan.
yes,
After repayment of the loan.
yes.
Now it is your duty.
My lord, yes, my lord, this is
Now,
correct.
but now you are saying that the sale deed has been lost.
No, sale
has
deed,
been
my lord,
lost
not
from-
not handover, not a document, my lord, placed, my lord, no
How can it be
handover to
loan
the
sent?
LIC.
Don't defend it.
Ma-
Come with clean hand before
No,
the
no, my lord,
if it is lost, you candidly admit that it is lost.
my lord, lost, my
Loan
lord,
can
which
be
position, my lord,
without
either promoter, my lord,
It
they are
may
the,
be lost. Huh?
my lord, the position, my lord, which position, my lord, lost, my lord. This is the, my lord, the IGR, my lord, handover to the developer. My lord, only my lord, affidavit portion, the IGR handover to the
Who
developer.
granted loan? You granted loan.
My lord, I have granted.
So inevitably you took the sale deed in your custody as
ma'am.
mortgage.
At the time
The
of
pop-
final disbursement, final disbursement was not made. But they have not taken full loan.
The
Partly loan was taken.
property was mortgaged to you,
My lord.
keeping the title deed deposited in your custody. The title deed was deposited to you,
Unless loan can
and you, keeping the property mortgaged, you disburse the loan. So after the loan is repaid, then it is your duty to hand over or return the deed to the person
my lord, this is the correct, my lord. This is the, my lord. My lord, as per the tripartite agreement, my lord, page turn, my lord, 43.
43.
43.
Yes. Page 43.
43, my lord, my lord, paragraph 8, my lord, just bottom, my lord, that in case the borrower commit a breach of the terms and condition of the agreement by his, her, and their in its failures, or to pay remaining balance to the remaining balance under construction flat. This is the, my lord, the partly, my lord, kindly, my lord, turn the affidavit, my lord, under construction.
Page 49. My lord, kindly go through page 49.
Under construction flat, my lord.
My lord, date of return of the all original document. LIC, my lord, since I repaid. Page 49.
My lord.
And loan repay, my lord, it was revealed from page 45 to 49. 49. Entire, my lord, transaction I have, my lord. My lord, loan will be zero, my lord, page 45. Loan account.
Page 48, 00.
00. Loan account 0. Well, now they are saying that I am not being. Well, apart from, kindly provide only certified copy. Let them.
It is good for them. Otherwise, I will pay for 5,000.
Well, kindly go through the RBI, my lord, instruction.
0.6.
0.6.
I handed it over.
I hand it over to your lordship. 0.6. That circular by the RBI. My lord, next page, para 6. Oops.
Yes.
If, my lord, your lordships, para 6. My lord, if not, my lord, return to the original, my lord, document, there is, my lord, within 30 days, there is a compensation, my lord, should be given, my lord, for each day 5,000.
For 7 years, 6 years.
Okay, so I am sending it to the ombudsman. That would be better. You say justify your action before the ombudsman. And it is the you are which bank? LIC. So you are also operating
Yes.
under the RBI. So under the RBI guidelines is binding upon you.
My lord.
Are you banking institution?
No, man.
Huh? So you are governed by which? Banking Regulation Act?
No, my lord. Banking regulation.
How?
guideline.
How?
My lord.
If Banking Regulation Act, then 21 and 35A, according to section 20, you are bound to obey the guidelines of the
My
RBI.
lord. My lord.
So you are dealing with the public money. So you have to maintain a high standard of fairness.
My lord, very fairly, my lord, this is the, my lord, affidavit opposition, my lord, the promoter, my lord, telling, my lord, not a produce single document.
You are shifting the liability to the promoter.
My lord.
You say that due to promoter negligence or failure or any fault or action, inaction, the deed had been lost from your custody.
No, my lord.
So how you will justify?
No, my lord, my custody, my lord, not my custody, my lord, admitted portion, my lord, not given the LIC. Cannot the page 9, my lord, paragraph 9, admitted for, my lord.
You certify if you lost, you what you have stated in your affidavit.
My lord.
You come with a report for.
My lord, I have not filed affidavit.
That whether it is available,
my lord, my lord,
whether it is available in your custody. You first, you took the deed from the borrower, admittedly.
My lord.
You keep it in your custody. So after repayment of the loan, it was your duty to return the deed to the borrower. Admittedly. It is common understanding. So now you could not return that deed on the plea that it is lost from your custody.
No, my lord, this is my lord, the facts, my lord, the telling me another thing. My lord, this is the problem. I'll my lord on that demand for the before the dispute, my lord, I resolved it. The certificate copy I will hand over the certificate.
Why certificate copy?
My lord, kindly, my lord, the what is the facts of
If
the case?
original is lost in respect of deed, you will never be able to give
My lord,
original.
my lord, original.
Original deed is one.
No, my lord, original, my lord.
Original deed is one.
Kindly, my lord, paragraph 4. I have stated all the facts. My lord, date by page, my lord, kindly, paragraph 4, my lord, I have stated all.
No, nothing you do.
No.
Whether you have lost or not.
No, my lord.
I am giving you 7 days time. You will return the deed in the court here and now. Return the deed.
My lord, try, my lord, try to, my lord, understand, my lord, the predicament, my lord, ask the promoter and they go when we have to.
I will not allow you to shift the responsibility to others. Otherwise, I am directing you fix the responsibility. Who is responsible for its loss from the custody of an responsible institution? LIC housing means it's a responsible institution.
My lord.
Housing, what? LIC housing? Finance Limited.
Yes.
LIC Housing Finance Company Limited. So, responsible institution.
My lord.
So, who is the head? Who is the head?
My lord, kindly, my lord, state of.
Who is the head of EA? You have made LIC Housing Finance Company Limited, but repainted by whom? Or the director, manager?
Eastern Zonal Office.
And you also not mentioned your designation. Dilip Koyal. Dilip Koyal working for Jain at Eastern Regional Office. What is his designation? Who is the head of LIC Housing Finance Limited Eastern Regional Office?
My lord.
Who is the head?
Regional manager.
Regional manager. Okay, I am directing him to appear personally before this court.
No, my lord, kindly, my lord, affidavit, my lord, kindly, my lord, only, my lord, the certificate copy, my lord, the sort out, my lord, this is the, my lord.
You resolve the problem.
My lord.
I am keeping it, or I am giving you 1 or 2 weeks time. In the meantime, you resolve the problem. How you will resolve? It is your headache. It will look out.
এই অপোজিশনের কপি দাও না আমাকে দাও আমাকে দাও আমি জেরক্স করে
Otherwise, I shall be forced to direct personal appearance of your regional head. Because such sort of indispensable dealing cannot be allowed to be continued. What? Choice is yours. Otherwise, I shall ask the ombudsman.
My lord, certificate, I will to provide certificate copy.
Certified copy with a certificate. Certified copy. You will get the certificate copy.
Proclaim certificate.
With you will withdraw the certificate copy and with a note sheet.
Yes, ma'am.
That it is lost from our department, and hence I certify that this is the certified copy of the original deed.
Mal.
And that must have signature of your regional head.
Mal.
Shall I pass the set order?
Mal.
Huh?
My lord, kindly not mal hanging the matter. My lord, kindly, my lord.
The present petition has been preferred for the issuance of
This is the respondent number 2.
The House Finance Corporation.
Yes.
House Finance Corporation is also discharged its function under the supervision of the RBI. Therefore, the RBI guidelines, in accordance with the provision of 21 and 35A of the Banking Regulation Act 1949, RBI guidelation is binding upon the respondent number 2. So resolve the issue. Respondent number 2 is further directed to fix the liability, to fix the responsibility of the person for whose negligence or action or inaction, the deed was lost from the custody of the respondent number 2, and to take appropriate action against that person adjudged to be responsible.
Yes.
Again, that erring officials or person adjudged to be responsible.
Yes.
Henceforth, you will not lose any deed of any person. Prepare a locker, not only to keep the valuable ornaments or such and such, to keep the deed of the people.
No, my lord, facts is my lord telling another things. My lord,
Yes, next. Huh? এটা কোনটা? আচ্ছা নিন তাহলে দেখি।
11 and item number 14.
Lord, I am filing my report in
My
the
lord,
form of
it
an
is
affidavit
that
and
matter
certificate
your
of
lordship considered that regularization as Gram Panchayat Karmi.
Oh,
That matter, I relied on Jagu's judgment. Your lordship wanted to see what is his initial credentials at the time of appointment. Therefore, my lord, you pass your lordship's last order. Kindly peruse the last order. They have filed today an report. We would like to file an exception to that, my lord. Kindly grant us some time.
the 14. 14 crore.
yes. So
I would like to file an exception to this.
respondent number 5 was directed to file a report in form of affidavit disclosing the stamp pattern of the Gram Panchayat as it stood in 2007. So what is the stamp pattern?
It is in my favor. Page 2.
It is in your favor.
It's not
Yes,
in
I
his favor.
am. Yes. I need to show
Okay,
my
okay, okay.
Kindly see.
Let it be to the
Yes,
court.
kindly see
Uh,
page 2.
What is the
I'll come back
his
with the
report?
exception.
Allow Mr. Pal to
Before that, my lord, I need to place my documents because I'm the petitioner. I need to place my documents that I am been considered by the
okay,
secretary.
I shall give sufficient opportunity to place your case.
Very-
Now the court is eager to know the staff pattern of
The
the
only
Gram
question
Panchayat.
was
Paragraph 3, my lord,
kindly see paragraph 3.
Paragraph 2.
Page 2, paragraph 3. The only question was at that point of time whether there was any vacancy or not, against which I have been
Not-
taken as casual
not only
employee.
so, it is a private arrangement
Kindly
between
see
the panchayat and the petitioner.
Article number 6.
Paragraph 2. Yes. in respect of the queries from the office of the answering respondent by number such and such.
See the tabulation.
In regards of the details, Mohammed casual worker Atho has furnished the information of the staff pattern as it stood in Atho.
See, yes.
Executive assistant as sanction 1, number of post in position.
6, serial number 6.
So Nirman Sajak and
6.
CPF Kormi was vacant. He was
Gram
engaged
Panchayat
as
Kormi.
Gram Panchayat Kormi.
Serial number 6. Kindly see there were 2 sanctioned vacancies.
Serial number 6. Two
Yes.
posts.
Posts were
The
there.
post was vacant.
Yes.
Yes,
Yes.
then,
Against
then,
which-
yes. Then the petitioner was engaged on 17 September 2007 as a casual worker by a resolution of Shahpur 2 Gram Panchayat under Gwalpakot 2 development block for helping day-to-day work of the Gram Panchayat. There is no reference of engagement of the petitioner against any sanctioned post of Shahpur Gram Panchayat in the resolution book so available. A copy of the resolution book was also annexed. Well, in this regard, a communication was received earlier from the block development officer, Gwalpakut 2 development block under Uttar Dinajpur by memo number such and such in regard to the submission of report, the matter of such and such. From the communication, it reveals as follows: there are no documents available in the Gram Panchayat or at the office of the block development officer, Gwalpakut 2 development block to establish the appointment of the petitioner was done against the sanction post. Appointment of the petitioner has been made as a casual Panchayat Kormi by resolution of the general body meeting of Shahpur Gram Panchayat, and for appointment to the post of Gram Panchayat Kormi, no approval or sanction had been issued from the end of the block development officer, Gwalpakot 2 development block. Gram Panchayat was unable to produce any papers in original related to the appointment of the petitioner. But that is a total.
Okay, that is your, it is the answer to the query of the court.
Yes.
That means the Gram Panchayat Kormi, the post of, there are 2 sanctioned posts of Gram Panchayat Kormi. And both the posts were vacant at the point of time.
Yes.
Then the Gram Panchayat adopting a resolution engage the pageant, engage the pageant.
My submission is this is a private arrangement between the Panchayat and the petitioner.
Okay.
No paper advertisement was given.
Okay, yes.
Now, whether the documents as acknowledged up to principal secretary that there was a vacant post against sanctioned vacant post, I was engaged. Now, it does not lie in the mouth of the state today to say that it was a private arrangement. Nowhere in the this affidavit, this word private arrangement has been written. Now,
Okay,
I will give the response, my lord.
okay. The pageant petition has been prepared, praying for the issuance of a Next. Slow হয়ে যাচ্ছে। হ্যাঁ, ঠিক।
Number 3.
এই মোশন করে হ্যাঁ, কোনটা? আমার আছে, দিয়ে দেবো, আপনি করে দেবেন। আমি তাহলে এক কাজ করুন, পেন ড্রাইভে দিন, আমি শীতপাল আর ওইটা ঢুকিয়ে দেবো। এটা একজন মোশনে দিয়ে দেবেন, একজন নট টুডে, একজন মোশনে সেই দিন দিস, নট টুডে নিন।
4.
The matter is about in the year of 2022. My lord, in the motion, my lord, today the marriage came up, my lord. My lord, kindly direct the service and kindly.
আচ্ছা, your name please?
My name is Shantanu Seth.
এই লিখুন তো যে Mr. Sadhansal, learned advocate appearing for the petitioner submits that service of a copy of this petition upon the respondent has not been completed. In view thereof, the matter stand adjourned for a period of 3 weeks. The petitioner is directed to complete the service of this petition, service of copy of this petition upon the respondents in the meantime. 3 weeks or 4 weeks?
4 weeks, my lord.
4 weeks, 4 weeks, 4 weeks. Yes.
Actually, my lord, it's a matter of 2022.
Ah, yes. I know. Next.
5.
5 দেখুন, ওই করে দিন, একজন মোশন করে দিয়ে দেবেন, সেদিনকে করা হবে, নট টুডে,
6.
সেদিনকে কাটা হবে। ওই নট টুডে একজন মোশন সেই দিন দেওয়া হবে।
7.
For default.
I am appearing on behalf of the respondent, item number 7.
Okay, let him give you another chance. Adjourn motion. If on that date they didn't appear, they does not appear, then
Your lordship.
yes, dismiss for default. What can be done?
8.
Same.
9.
Same. Yes. Have you served?
Yes, long before my.
Long before. The problem is that.
Let the matter be.
So what can be done? You serve in the meantime. I am fixing another date.
Yes, sir.
That would be better.
That will be better.
Achha. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Despite service, the respondents are unrepresented. Stop. I am of the view that presence of the representative of the respondents is crucial for effective adjudication of this petition. In view thereof, petitioner is directed to serve a notice upon the respondent intimating that the matter shall be taken up for hearing on 27th August. Next.
10.
My lord, in regarding item number 10, I am appearing on behalf of the state respondent number 1, my lord.
Okay, I am giving chance to everyone. It will appear under the adjourn motion on that date.
My lord.
Necessary order shall be passed.
My lord.
Achha, not today.
My lord, my name might kindly be recorded.
Not today, on that date.
Grateful, man.
Okay.
11.
Same.
12.
Same. Right there.
Number 13.
Time for the petition.
Who is your other side?
Please follow 5 and 6.
Party on behalf of the state. That pond.
Yes.
Embankment on pond.
My lord,
I have given the.
Have you brought the West Bengal Inland Fisheries Act? 17 days.
that will not be applicable to this case. I say, my lord.
I have, my lord, I am the owner in respect of that number.
You are the private respondent means
We are the owners of the pond.
owners of the pond.
I am,
But who is the owners of the embankment of the pond? You. You sold out the land.
No, no, no. His land is, my lord, beside the pond, adjoining to the pond.
You also constructed building
No, no,
on.
no, no. The big
My lord,
pond, my lord, in rural
my-
areas, my lord knows, my lord,
property,
they are
my-
big ponds.
you know, my,
Big ponds. It's a
I am
big
the
pond.
owner in
My
respect
lord,
of.
what he has done, my lord, I have.
My lord, I am the owner in respect of plot number 736. My lord, pond is upon.
Mr. Chakraborty, I am sending it to the district inspector, the district magistrate being the collector. He is responsible to ascertain so the nature of the land is not changed,
Yes.
classification, and the district fisheries officer. Both will consider whether your action is legal or not.
Your lordship, highly, first of all, my lord, kindly hear the problem and then solution will. My lord, my property, my lord, kindly see the photograph. My property situates at Dag number 736. I have made construction of my building in my property in the year 2002 with the consent of the owner of the pond and as well as with the, my lord, sanction of the Panchayat authority. And to safeguard my property, I have constructed.
You want to fill this portion by earth,
No, not at all. I
fill
want,
this portion to save your wall.
I not. My lord, what
Huh?
happened?
That means that action will result in filling up the pond.
No. I'm not
This is
asking.
contrary to the notification I have referred.
Not filling, my lord. Kindly see. I have prepared my house and also to safeguard my
It is panchayat area or municipal area?
Panchayat.
Panchayat.
Panchayat area. Gam panchayat sanction your plan.
Yes, I have,
So-
my lord,
so-
kindly see the pond.
First you show what is the nature of the classification of the land.
Classification Vastu, my lord, kindly see.
Where from?
Page 45, page 45.
Page 45.
I have constructed upon my own Vastu land.
Oh, this problem is going on. And page 45 in an application,
Original edit, my lord.
you just show that land was classified at Vastu. It is an application.
My lord, this has been sanctioned, my lord. Next page, my lord.
Land was converted to Vastu.
It is originally Vastu.
You show that.
My lord,
I know originally Vastu. I am ready to accept.
next page, next page.
Next page, yes. Gam Panchayat is not the authority.
Hello, that is not the problem. My lord, kindly understand. I constructed house in 2002. My lord, in the year 2015, the pond, my lord, their pond was there. And to fill up another doba by the side of the pond, the government, as per the Mahatma Gandhi some scheme, the government removed the earth and took away the earth below my guard wall. Remove the, due to removal of the earth, the guard wall become without support. That's why my premises, my lord, became endangered. My lord, if kindly, your lordship have seen the guard wall, and if the land beneath the wall is removed, what will be the result? The result will be the building is becoming, my lord, cracked, and it has leaned in some portion. My lord, thereafter, my lord, I filed first writ petition. My lord, and by filing the first writ petition, my lord, an order was passed by Honorable Justice Somapti Chatterjee. My lord, kindly see that order with আমার petition কপিটা একটু দিন ওখান থেকে নিয়ে। Well, order was passed, যেটা আমি দিলাম।
Directing the assistant engineer.
Yes.
Assistant engineer is not the authority.
Assistant engineer, and he will take help of the executive engineer that attain finality. My lord, kindly see. So many water flow in the Ganges. That order attain finality, but that was not followed. My lord, instead of my lord doing the same, my lord, it was done by another officer. My lord, therefore, I filed second deed, the instant deed. My lord, kindly see instant deed. My lord, kindly see the how many orders have been passed. My lord, kindly see. The orders have been passed, my lord, kindly see, my lord, first your lordship kindly see, order dated 2nd of July 2019. So 2nd of July 2019, my lord, kindly see. That will order sheet. My lord, kindly, the petitioner is agreed that the order passed by the Honorable Justice Samapti Challenge. The petitioner is aggrieved by the report of the assistant engineer filed by the present writ petition. Mr. Patro, learned advocate appearing for the petitioner submits that by the act of excavation, by the act of excavation of adjacent pond, the petitioner dwelling house, I have not excavated the pond. Petitioner's dwelling house has been damaged. Therefore, in earlier occasion, this court directed the executive engineer to file a report to that effect. Unfortunately, the assistant engineer filed the report instead of executive engineer. Assistant engineer filed the report, but not by the executive engineer, as has been directed by this court. That being the scenario, I direct the executive engineer upon giving notice to the petitioner to inspect the alleged disputed plot and file a report to that effect by 12 July 2019. Thereafter, subsequent order, next order was passed on 25th of November 2019. Well, I'm reading that order. Notwithstanding an earlier order dated 2nd July 19, the executive engineer has failed and neglected to file report in terms of the said order. By the said order, the executive engineer was directed to file a report upon notice to the petitioner in respect of the alleged disputed plot by 12 July 2019. Council on behalf of the state submits that the executive engineer will positively file, and the government says executive engineer will positively file the report within 2 weeks from the date. Let this matter appear on 9 December 2019 to ensure compliance of the executive engineer. And thereafter, my lord, another order was passed, my lord. That order was passed by Justice, my lord, Talukdar, by which, my lord, the executive engineer was also added as a party. My lord, kindly see thereafter, my lord, your lordship kindly see the order report was submitted by the executive engineer. My lord, kindly see the report of the executive engineer, my lord. Your lordship, my lord, have your lordship got the report of the executive engineer? Executive engineer, my lord. As per the court's direction, executive engineer in connection with the second writ petition, my lord, made my lord inspection and submitted report. I am, my lord, if your lordship have no copy, my lord, I am supplying the same, my lord.
What the
My lord, I'm reading the report, my lord. I have a copy of it. My lord, kindly see that. This is the report submitted before this honorable court. Last portion, my lord, he has suggested for taking steps. This is the report of the executive engineer passed in as per the direction of this honorable court in connection with this writ petition. My friend cannot have any objection because
You just show that
last
the plot number 736 was classified as Bastu.
Yes, yes.
Bastu. Have you brought any document to show that it was Bastu?
Definitely, definitely. I'm showing it.
Where is that?
There is no dispute to that effect, my lord. My lord, I can show the purchase, my lord.
That's so you show. That at least so. It was converted to.
Originally, it is my ancestral property.
Mr. Bari, whether it is Bastu, you didn't take instruction.
1136.
Whole matter after long gap, it's coming, my lord.
Now, on earlier date, it is the 23rd July, it was taken up for hearing. You saw that land is Bastu.
One report was filed, but perhaps on behalf of the state, my lord.
I see the report of the state.
The report was filed.
My lord. Not in the form of affidavit, but only a report.
This is the report I still in your. That is also my lord. That will also show that my property is under 736. So there is no dispute regarding the same one. I do not want to touch the my lord. What my lord, your lordship, I have shown the position of my premises. My lord, the land has the earth has been removed from the below.
Okay, so I am referring to the district magistrate. He will look into the matter. He either himself or by any person deputed by him, and he may consult also with the district fisheries officer. And if he finds that there is no violation of either West Bengal Land Reforms Act or Inland Fisheries Act, then they will allow or permit you.
I have no money. I have 8 lakhs. I have
Okay. Then the district magistrate, if found that illegally the earth was removed, which was serving as a lateral support to your guard wall, guard wall, then he shall take appropriate steps.
He shall fix responsibility upon whom, for whom that has been done, my lord.
My lord, if the lordship may pass on.
You do it on your own cost. Now you are now trying to realizing the cost from the state.
One thing may I indicate, my lord.
My lord, it is a huge. My lord, it has been done at the instance of the state. Huge. I am not in a financial.
My lord, I have last occasion I have handed over a document, my lord, where my lord a notification has been quoted, my lord. Kindly refer to that.
What notification? Tell.
My lord, it says, my lord, to protect the water bodies from encroachments, erection of any encroachments or erection of any boundary brick wall around a pond should not be undertaken. What he had done, my lord, it is
No, but neither
against-
government has issued any, my lord, step against.
He is not interested to erect any boundary wall.
It is there.
He just want to protect that existing boundary wall, existing guard wall.
Existing.
It is.
100%.
Okay, I can record it.
Yes.
So, my lord, the guard wall.
Okay, which notification is
I have handed over the, my lord.
Existing
That order, yes.
Huh?
That order. That guard wall is itself is illegal. Kindly come to page 22
Or 22 of?
of the my lord, that. It has been quoted. The West Bengal government notifications statutory circular. It starts from page 20. Bottom.
7, 8.
My premises has been constructed.
Page 20.
Page 20 bottom is the number.
I have
It
constructed.
is not properly paginated.
No.
You open it for me.
Etana. That is the Tripura High Court judgment.
Tripura High Court judgment, yes.
The notification will quoted. My lord, kindly come to page 21. Bottom page number is there.
Yes.
This is the West Bengal government notification statutory circular,
2007, my premises.
and my lord,
2002.
kindly straightway come to page 22.
And I am not. Suppose I
In pursuance of the submission and queries from the Department of Environment,
Page 20, my lord, 22.
constituted a committee for determination of the nature of embankment of the water body in the state of West Bengal involving representative of the Kolkata Municipal Studies West Bengal
This is the
Department of
notification and what to be done, what not to be done. Kindly come to paragraph Roman 5, page 22. Top paragraph,
to protect the area for
to
encroachment,
protect water. Yes.
erection of the boundary of any boundary equal around the port should not be undertaken.
Yes.
This
What he has
boundary will
constructed,
deny
my
the
lord?
free movement of amphibians to and from the water and land. This wall also prevent the surface runoff boundary.
So already the guard.
In municipal area, who was?
This is
In
not.
Panchayat, who was the authority?
Everywhere, my lord, the district fisheries officer.
Okay. Now allow the court to pass the order.
Hello, this is the 2007.
Okay, if you do not violate
Yes.
any provision of Land Reforms Act or West Bengal Inland Act
If
or
there is
any
point or then I have second read.
any-
Another read.
circular or notification issued by the environmental laws by the state government, then nothing they will.
Yes.
But you bear your own expenses. You do at your own.
My lord, it has been done at the instance of the state. And my lord, I have,
And the present petition has been prepared.
kindly see, my lord.
Seeking a directive to the concerned respondents to take adequate measure
Yes.
to protect the guard wall, to protect the Not mentioning time, don't mention.
No,
all the time.
Milord, kindly keep the matter in the monthly list of September. I think it was called, Milord. I was in court number 4 then.
Right, 10 television as prayed for on behalf of the petitioner, let the matter go out of list, liberty to mention.
Monthly list of September,
Okay,
Milord.
okay. Okay, next. Yes. 10, item number 10.
Well, I have for the petitioner, my lord.
Mhm.
I'm led by Mr. Mojumdar, and day before yesterday, Mr. Mojumdar has submitted regarding the appointment in a particular school which is not governed by the rules of the SSC, School Service Commission.
May I just indicate before my learned friend proceeds?
Mhm.
This school, which it is a minority institution. In the writ petition, it appears, my lord, that at page 25, an order has been annexed. My lords may kindly take the pains at page 25.
A.
Page
25A, come to 25A. Yes.
25A, yes, my
Mhm.
lord, that is better. Now, here, this has been clearly indicated that this school is a minority institution, and my lord, the particular, your lordship knows, my lord, very well, my lord, better than from me, that under section 15A
Yes.
and 15B of the West Bengal School Service Commission Act 1997, the particular rules or the particular act of the West Bengal School Service Commission is not applicable insofar as a school which is a minority
Run by
institution.
minority,
I'm grateful to my lords. Very
religious or lingual.
I'm grateful. Now, my lord, kindly come to for 1 second, my lord. I will be showing to my lords only 2 documents, nothing more than that. Page 26.
Better document 26A.
Beta document is at page 26A. Eta to see.
Yes.
The serial number 2, Sri Ramakrishna Vidyapit.
Yes.
Shuri district, Birbhum. This is the school for which I am appearing on behalf of the school. Now, significantly, my lord, it appears that process of selection was started. My lord, before I proceed, my lord, I will not be taking more than 2 minutes, not even to say. My lord, kindly see section 15, A and B. Just I am handing over to my lords. Kindly come to my lord, Josephke বইটা দিয়ে দেবেন।
এটা একটু দেবেন দাদা।
Josephke দিয়ে দেবেন। Kindly see section 15A and 15B of the West Bengal School Service Commission Act. 15A and B, that makes it clear
Yes.
that as your lordship indicated, that this has got no manner of application. Now they impose, the authorities, they pass an order which is the subject matter of challenge, that is at page 65. And your lordships will be pleased to find from the particular order which they have passed.
51, sir.
Page
51.
Page 51.
Page 51. Miller, your lordships will be pleased to find
Page 51.
at page 51,
Yes.
the West Bengal School Service, Miller, they apply a rule of Miller. Ruleta de? Oh, Miller, I'm sorry. and 52 হচ্ছে গিয়ে তোমার সাবজেক্ট ম্যাটার অফ চ্যালেঞ্জ।
এটা তো
হ্যাঁ, এটা ঠিক আছে। 28/8/2013, 28/8/2000।
এটা হচ্ছে তোমার 13 31
হুম।
Schools, West Bengal School
School Service Commission.
election. So this is not applicable.
Now the authorities proceed by applying the rules of the West Bengal School Service Commission. But it cannot be done because this is a minority institution. Kindly see, my lord, I leave it to my lords.
Specifically mention করা আছে, বাকি mention করা নেই।
Oh, yes.
Now,
Yeah.
Lord, I also further find that they have, my lord, applied a rule. এটাই তো সেই রুলটা তো। হ্যাঁ,
জিও করা আছে।
হ্যাঁ, my lord, that they have applied this rule under the West Bengal School Service Commission, and I find that this has been done under section 17 of the book, my lord, which I have handed over. This is not applicable. And kindly say section 17 that my lords will be pleased to find at page 517 of the book which I have handed over to my lords. This rule is not applicable insofar as the school is concerned. There are two
Non-teaching staff, that
Yes.
rule, 2013.
And Millard, kindly see, Millard, my lords have laid down the law that Millard, a minority institution, it enjoys a power of right to establish and right to administer.
No, it is 13 rule, 2007 rule. It is teacher.
Teachers,
It is teacher.
yes,
our post is for the
It-
teacher.
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 Teacher
Oh.
for Bengal.
Okay, okay. And he is referring the rule to 2027. And it is for non-teaching staff 2013.
Millard, I say, Millard, kindly quash the order and direct the authority to, Millard, ensure that the rules for, if there is, because I have checked up. I say, Millard, with my very little ability, I have checked up whether there is any rule for the minority institution. Now, from the available books, I could not find anything. But if there is any government circular or anything to that effect, that I cannot say. But kindly direct them this thing, that they should apply the particular rules which are applicable for a minority institution. Having regard to the nature of the school, you are applying a rule which is non-existent or which cannot be applied insofar as the given school is concerned. Therefore, this is my respectful submission.
Yes.
I,
Learned
Sir
advocate
Millard, I
from
do
the
not
state.
want to add anything.
If it is, my lord, fallen from this, my lord, submission of the senior council, my lord, that as per, my lord, section 15A or, my lord, this rule is not applicable, then entire thing goes. I am, my lord, then entire thing goes. But, my lord, then the petitioner shall not give any appointment.
What?
As such, my lord, the case.
So minority in, so there shall be no appointment
No,
with
no,
minority in
kindly see
citizen.
the August 27, 2013 rule, there was specifically that school means such a school as notified under section 15A. What do you want to submit before Lordship? That entire rule is not applicable. That is not. The procedure has to be followed by this rule. But the special rule under section 15A amended, that is the procedure. Milord, may be wrong, Milord. I have in a matter, Milord, I argued the matter that in a transfer policy, Rule 15A or the school authority like Ramakrishna Mission or any other minority institution, that has to be followed. But in this case, the procedure of selection of teaching or non-teaching staff, as per the Rule 2013, shall be guided. As otherwise, the procedure has to be followed under which rule? That has to be, Milord, satisfied before Lordship, Milord, by the council. One thing.
Now you say.
Yes, Milord, I have to come back on this regard. But
you have to come back when again and again you will come back
that is
and go.
first time raised. That point is first
Court
time
will
raised.
go on time. No.
That point is first time raised. Now, Milord, second thing. Second thing is this, Milord, the entire petitioner's case is based upon information derived from a reply for a RTI Act. Your Lordship's kindly gone through this writ petition entirely. The petitioner initially made an application under RTI before the authority of the school authority. School authority giving the reply. Kindly see, Milord, the page. Milord, page 13 of the writ petition. Page 13. 13. Paragraph 13. Paragraph 13.
Which page?
বলছি Milord, paragraph 13, that interview was held in the year, Milord, 20th January 2019. And thereafter interview was held, that is Viva Voce, that 29th May 2019. Milord, the RTI made, Milord, page 44. Milord, I am wrong. Milord, page 44.
It is not clear whether anyone cannot rely upon the information.
What circumstances here in this case to decide? The petitioner made an application.
You just justify your refusal.
Milord, I am
allow the court to say something.
Yes, Milord.
Okay. You are the counsel. You will get the opportunity to say everything in the court. But allow the court also to say something.
On this,
you justify your action of refusal to grant approval to the petitioner appointment.
Yes.
You justify.
Yes.
If you can,
I shall demonstrate. I try to demonstrate.
The sufficient reason was there.
Yes.
Then court will have to accept.
I shall demonstrate in each and every point discussed in the writ petition, Milord. The RTI reply has been given by the school authority. Decline the prayer of the petitioner. That is why I am saying, Lord, even if today senior counsel appear on behalf of the school and supporting the contention of the petitioner, that may be not tantamount against the petitioner. As such, Milord, the reply given by the school authority under the RTI Act against the petitioners. Then, Milord, subsequently, Milord, the development, petitioner has not challenged the order of the school authority by through the appellate authority under section 19 or subsequent authority to the Information Commission. But in this case, Milord, thereafter in the matter, Milord, the honorable single bench, Milord,
come to the point of law.
Milord, kindly see. Milord, kindly
you
see,
rejected on that date.
Milord, I said
on that date, I was told and I was shown a document. You rejected this petitioner pair for approval is appointment on the ground that the selection process has not been completed within 120 days.
120 days.
That was given in a 9 month.
Mr. Mojumdar draws my attention at that time.
So, Milord,
attention that should be 120 days. The court asks the question where legislature use the word should be.
Yes.
And there is no default clause. can it be treated as a mandatory?
Yes, my lord. If there is no
Ah,
default clause,
You
then that,
come to the point of law. You are all
my lord, the rule, in the rule, if it is not silent, if it is silent,
that apart, you are citing certain irregularities. Irregularities
or
in
anomalies in the
conducting the selection process.
which was held by-
Mr. Bhattacharya and the senior counsel, he has stated that you cited those irregularities on the basis of the such and such rule.
that rule is
And
not.
the rule was framed under West Bengal School Service Commission Act. West Bengal School Service Commission Act is not applicable to that school.
Regarding that, my lord, regarding
You just give answer to this
yes,
query.
my lord, I shall come back and my lord satisfy your lordship.
I again come back.
My lord, method and procedure has to be followed under this rule 30.
Characteristic of a
Oh, so Article 29. Yes. Article 29 has right. Right of the religious or lingual.
Therefore, the
Uh,
initial
it's,
rule
religious
to say applies
institution
is
too.
wholly without jurisdiction.
Then, my lord, the
Take the point of
entire thing is
jurisdiction.
will reopen.
I need
If
not
it
go
is, my
into
lord,
the
the
other merits.
entire process under the rule has been guided by the authority. That is valid in law. If it is prima facie, then will Mr. Majumdar submit that the rule 120
And
days.
Mr. Bhattacharya submitted
I
that despite efforts, he didn't find any rule formulated by the state to be followed by a minority
Then, my lord,
institution while conducting a selection process.
then,
You show
then, my
that
lord,
it is the
after
rule.
yes, rule 30, my lord, in my lord.
Yes, petitioner has claimed on the basis of the information supplied to him in
My submission is this, my lord, the rule
All
which
the
was
things
shown to your lordship,
said is
which is
irrelevant.
guided for the.
I could have disclosed of the institution if you give the answer to this.
Well, I shall come back. I shall come back.
Huh?
Day after tomorrow, you are kindly lordship fix that. Tomorrow I have some difficulties.
Yes.
Keeping lunch.
No.
1:30 or
I was thinking that you are waiting. Yes.
Well, kindly turn the page 302.
102, yes.
302. These are the notices thereafter. These notices and the order of eviction is subject matter of challenge before my lord. While challenging this, kindly record my submission that we have challenged this, and our contention is the lease which was there, which was continuing till কোন বছর পর্যন্ত continue করছে? 2037.
You have challenged the notice dated September 17, 2008 and a communication dated 16 February 2019, 2009.
Starts at 300, 11 continues. There are so many orders. Now it appears from the affidavit that the estate officer has himself was this. So that we can be concluded that proceeding is bad. There is no eviction. This is the malord will straight away say that this is becoming infructuous.
এই আমার অর্ডারের সিট গুলো কোথায়?
পার্ট 1টা দিন, পার্ট 1 এর মধ্যে থাকবে।
অর্ডারের সিটটা দিন। ইয়েস।
ওইটা মনে হয়।
হ্যাঁ?
ওইটা মনে হয়।
এটা বললা রে কবে?
2037 থেকে থাকে। 37
এটা কোথায়?
ইয়েস।
আগে যে লিস্টটা 77, তারপরে দুটো রিনিউয়াল, একবার রিনিউ হয়েছে, রিনিউ হওয়ার পর নেক্সট হচ্ছে 2037।
নিয়ে পড়াচ্ছে।
নবান্ন অভিযান হচ্ছে বুঝতে পারছেন,
চেম্বার করতে হবে।
ফর দ্য পিরিয়ড 30 ইয়ার্স, এই 30 ইয়ার্সটা শেষ হচ্ছে। উই হ্যাড এক্সারসাইজড 77, তারপরে
Well, it need not be troubled with the entire record my submission and dispose of this matter on the basis that it become infructuous. Why I am saying? My lord seen what are the subject matter of challenge. Now the order which has not been placed before my lord, estate officer himself says proceedings are bad.
Yes.
So going back to the order of prior to the order of eviction, the lease which was there, it will be expiring in 2037. And I record this as my submission. And I will apprise the authorities that it is continuing. So kindly, I am ready to pay, kindly extend. That's all.
Ready to pay me?
That I am ready to pay and dispose of হয়ে যাক। That will get unnecessary burden দিয়ে খেলা।
আপনি যে পেমেন্ট করে এখানে
স্বাভাবিক তো, দোষণ তো দেখি। কথা বলছি জানো, তুই অনেকদিন অ্যাডভোকেট জেনারেল হয়ে গেছিস, এখনো বলছিস এসব কথা।
টাকাটা দিয়ে
দিয়ে দেবো তো, এক্সটেনশন হবে। This can be disposed of on that house.
So, on 18th April 2025, you said that company has offered to pay an amount of ₹10 crores and odds and the schedule lane.
Everything. I am ready to pay the entire demand of the KOPT. Let them that I lost ask for my lord. The my lord said, why you are bothering me? Up to 2037, please will continue. I will pay the entirety. This is my submission that I record and make it infructuous on the basis of the subsequent order passed by the estate officer that the proceeding is bad.
So,
there are two ways of solving the problem. One is simply recording and disposing of the writ petition.
writ petition has become infructuous.
Yes, that's all. But if he wants anything more,
I'm asking, I said record my submission and then pass
no,
the order.
this submission is not required.
Yes.
No, no,
Subsequently,
no.
I was thinking so.
Subsequently, whatever I submit to record. Whatever
Every
I submit to
submission is
record.
not to be recorded when my learned friend is of the view that in view of the estate officers of order, nothing remains in the writ petition, your lordship records that. But rent, balance amount,
Yes.
these are required to be
But
recorded.
your junior before rising, junior saying that let them a direction be given so that they shall continue to pay that amount and schedule lane.
Give that direction, I'm happy.
Eh?
10 crores, let them pay within a period, they whatever they say.
Whatever due, I'll make it whatever due, I will pay.
No. 10 crore. And they will go on paying as per the schedule of rate as whatever is prevailing today.
I think one of that going into that controversy.
আচ্ছা আপনি
Submission that I am ready
আসুন
amount that is the order, my submission.
Yes.
No, submission must be followed by an order.
May not be. May not accept that. That's why court has
That's-
not passed their order.
That's
challenging the justifiability of has not
No, that I appreciate.
actually against the some official of the podcast.
Well, I am praying for them.
You say that Mr. I have personal reverence to him and respect to him also.
No, definitely.
Don't.
In the next,
What I have stated against the podcast.
right. That is what I am seeking, Millard, your lordship's mercy to Millard. Millard, please take paragraph number 5 at
Yes.
page 16.
Yeah.
The order starts at page 15, para 5.
Yes.
Well, after Mr. Shah's
yes, such a stand.
yes. But if your lordship kindly consider, Millard, I mean, Millard, withdrawing this paragraph 5. Otherwise, Millard, this my officers may, Millard, be in some trouble, Millard.
Such a stand on the part of such and such dealing with concluded that if this order allowed to stand, it may entail disciplinary action against them. So the order has been recalled. Order has been recalled.
Order has been recalled, but this paragraph may, Millard, put them in some trouble, Millard. But I am praying, Millard, for your lordship's mercy to, Millard, expunge paragraph 5. Well, I believe, subject to your lordship's correction, without paragraph 5, Millard, I don't think the order will get affected.
The order dated, entire order dated has been recalled, or any further
Yes, I quite appreciate what your lordship is observing. But Millard, kindly consider, Millard, this part, because they have requested me, Millard, they may be in some trouble. I leave it to the court.
No, we have also difficulty. If subsequently there is a writ petition, we have to fight for them. That's the problem.
So I am to narrate the facts to some extent.
No, my lord,
least.
I can recall
I
the
can-
lordship. So
yes.
your lordship can, subject to my lord's pleasure.
Kindly expunge only paragraph number 5.
Expunge this part of the order. That's your lordship already recall that. On technically, my lord is 100% correct.
Yes.
আচ্ছা আপনি আসুন তো আচ্ছা Mr. Dr. Lanet, senior advocate, representing the
55. Okay.
155, my lord, Mr. Partho was appearing virtually, your lordship.
Yes, my lord. This matter.
That matter.
Yes, my lord. Last day I have concluded my argument. Only I am to reply the submission made, what will
yes.
be made by my learned.
Fourth round of litigation as
I
got
shall not say today, Mr. Das, to be brief. Otherwise,
I will
Mr.
much of time, my lord. Only one.
Otherwise, Mr. Das will express annoyance.
No. I will not, my lord. It's only a very
Actually, I have 913 matters.
and various subjects on various subjects,
Okay.
various determinations.
Yes.
Oh. It becomes very
Oh,
difficult.
what can be done? We are.
I will
we
not
are
take much of
bound
your
to
lordship's
give
time.
Patience hearings to all.
Yes.
But
That
so
we are
many
grateful to your
matters,
lordship, my lord.
matters we are
Is very
we
precious
are
to us.
to deal with a day, and hence we ask them, you briefly state, and
I have
your point will be dealt with accordingly.
No, my lord,
So
I will
be brief.
Yes, I will be brief, my lord, in my
Yes,
submissions.
yes.
I will just show few paragraphs.
Yes.
Already your
No,
lordship
no, you make your submission.
and 2-3 judgments and nothing else, my lord.
Yes.
As your lordship knows, my lord, this is the fourth round of litigation between the parties.
Yes.
Yes, my lord. What happens, my lord? There is the unauthorized absence from duty for about 22 months from 18/9/1992 till issuance of charge sheet on 15th of July 1994. My lord, charge sheet at page 43 of the writ petition. Now, lordship will find page 43. 18/3/1992 till date, the date of issuance of charge sheet was 15th of July 1994.
Yes.
Now, my lord, thereafter, my lord, the inquiry proceedings were concluded and the petitioner was dismissed from service on 7th of October 1994, which is at page 44. Type copy is at page 44A. Page 44, type copy is at page 44A.
Yes.
This was the order, my lord. Now, thereafter, my lord, several litigations regarding the same order, my lord. What happened, my lord? The pinpointer was the order dated 29th of January 2009, which is at page 69. It clears everything. Now, it is at page 69. It starts from page 69, my lord. I will go to the order, my lord.
Yes.
Now, my lord, here, what happened in this order passed by Justice Dottu, my lord? May I read out, my lord?
Yes.
Page 70, my lord. The last paragraph. Questioning the order of dismissal from service, the petitioner invoked the writ jurisdiction of this court by filing CO number 16428W of 1995. That writ petition was disposed of by this court on 18/9/95, granting leave to him to file a representation before the authority concerned within a month, and it was directed that if such representation is filed, the authority shall consider and dispose of the same within a period of 4 weeks from the date of receipt thereof, upon considering the fact that he was ill at the relevant time and was confined to hospital. The petitioners duly filed a representation availing of the leave granted by the court. In the said representation, the petitioner narrated how he was prevented from giving reply to the charge sheet and to raise effective defense in the inquiry that followed. I stopped there. Thereafter, the manner. Next paragraph. The general manager, Kunusturi area, upon granting the petitioner an opportunity of hearing and on purported consideration of his representation, maintained the final order of dismissal, holding inter alia that the same had been rightly passed. In arriving at such finding, the general manager observed that the petitioner had not produced any certificate or papers to show that his sickness continued even after 5/1/1993 till 27/1994, when the charge sheet alleging unauthorized absence was issued to him. It was also observed by the general manager that the petitioner, though residing at a place near to the colliery in question, had not sent any information regarding his alleged sickness for the period 1993 to 27, 1994, and therefore he was satisfied that the petitioner was not interested in retaining his service. The entire disciplinary proceeding as well as the undated order of the general manager rejecting the petitioner's representation are the subject matter of challenge in the present petition. So what was the subject matter? The entire inquiry proceedings, that order passed by the general manager. So that was the subject matter of the writ petition before Justice Datta. Now, my lord, at the outset, my lord, there was the, my lord, Mr. Roy, learned, their last paragraph, my lord. Mr. Roy, learned counsel for the petitioner, raised the following points. My lord, kindly note it. The charge sheet disclosed close mind of the disciplinary authority. The petitioner was given 48 hours to reply to the charge sheet, which was inadequate. Then, my lord, the fact that the petitioner was admitted in the hospital from 8/9/1992 to 6/1/1993 was within the knowledge of the respondents, and therefore the charge sheet alleging that the petitioner had remained absent without authorization from 18/9/92 till date of its issue is defective. I pause here for a moment, my lord. Can you see the submissions? So he says that he was in hospital from 18/9/92 to 6/1/1993. But the absence was from 18/9/92 till the date of issuance of the charge sheet, which is in July 1994. The petitioner was not given opportunity to engage a co-worker to assist him during inquiry, and the punishment imposed is thoroughly disproportionate. There has been no proper consideration of his representation. This was the submission on behalf of the petitioner in that writ petition. What the court held thereafter, it's very important. Having perused the charge sheet issued against the petitioner, this court is unable to uphold the contention of Mr. Roy that the same has been issued with a closed mind. The allegation appears to be that the petitioner had absented from duty from 8/9/1992 till date of issue of the charge sheet without any information or authorization, causing disposition of the company's work and inconvenience to fellow workers. It passes the court's comprehension as to how such a charge sheet could be said to have been issued with a closed mind. The allegation was that of absence without authorization and information, and therefore no illegality is found in the wordings of the charge sheet. So court found there is nothing illegal in the charge sheet. Next paragraph. The next contention that the petitioner did not have adequate opportunity to reply to the charge sheet, although attractive in the first blush, does not impress the court on scrutiny of the development during inquiry. It is no doubt true that giving 48 hours to an illiterate employee like the petitioner to reply to the charge which is leveled against him in a foreign language is inadequate, but this ipso facto would not enable the court to hold that the proceedings should fall through only on this ground. The petitioner could have, after receipt of the charge sheet, prayed for extension of time. Even he could have replied to the charge sheet prior to his participation in the inquiry. Having not taken recourse to any of such steps and having participated in the inquiry without raising a demur that he had been prejudiced by reason of non-grant of sufficient time to reply to the charges, it has to be held that he had waived his right to have more time. On an overall assessment of the processing of the inquiry, it does not appear that the petitioner was denied reasonable opportunity to contest the charges, and therefore this court is unable to hold the inquiry to be vitiated on this ground. So the court holds the inquiry proceedings is also not suffering from any infirmity or illegality. Further, mere fact that the respondents had knowledge of the petitioner's admission in the hospital during 18/9/92 to 6/1/1993 rendered the allegation contained in the charge sheet defective, which is the third contention, is equally without merit. By applying the doctrine of severability, this court would hold that the petitioner was accountable for the period from 6/1/1993 till date of issue of the charge sheet, and there being no sufficient explanation furnished by him regarding his absence during such period, mere inclusion of the period from 18/9/92
till 6/1/1993 in the charge sheet itself would not vitiate the order of penalty passed on inquiry against him. The applicable rules governing the inquiry permit a delinquent employee to obtain the assistance of a co-worker to assist him in the inquiry. According to Mr. Roy, the petitioner was not allowed such assistance. Upon consideration of the applicable statutory provisions, it appears to be an enabling provision, and therefore the petitioner could well have availed of the right that is conferred on him by praying for engagement of a co-worker to assist him in the inquiry. It is not improbable that the petitioner may not have known that he was entitled to the assistance of a co-worker, but on wholesome appreciation of the facts of this case, this court is of the considered view that even if he had been allowed the assistance of a co-worker, the same would not have established his innocence, since it is an admitted position that the petitioner did not send any intimation to the colliery authority during the period he was absent. The charge having been established by reason of non-production of material documents for which the onus lay on the petitioner, this court is unable to accept the contention of the petitioner. The last contention, so long this much, my lord, it establishes, the court holds, there is no infirmity in the charge sheet, there is no infirmity in the inquiry for proceedings. So that much the court held. Now thereafter, my lord.
Regarding the punishment was held as disproportionate.
Disproportionate means,
and hence the
what?
issue was
Court did not hold it directly, it's disproportionate. What the court held, court said, considering his community, considering his condition, you consider, you reconsider. That was because otherwise the court would have said it shocks, because where it is said to be disproportionate.
Shockingly disproportionate.
Yes, where it shocks the mind of the court.
Not commensurate with the gravity of
the consciousness of the court. Unless and until it is held by court, it cannot be said that it is disproportionate. Court didn't hold so. What the court held, my lord, the last contention of Mr. Roy, that the punishment is disproportionate to the gravity of the offence committed by the petitioner, coupled with the fact that his representation has not been duly considered, however, has impressed the court. During the 3 years the petitioner was in service, there had been no allegation of unauthorized absence. Maybe. The cause of action giving rise to the charge resulted from his ill health. The petitioner, being a member of the weaker section of the society, has to fight for his survival. In a case of this nature, the attitude of the disciplinary authority should not have been that of a hard taskmaster. Some amount of leniency could have been shown. The petitioner, having in his representation narrated the fact that he had been treated by Ojha at his native village, which is not uncommon, and for which obviously no material papers could be available to him, it was incumbent on the general manager to consider the claim for reinstatement of the petitioner on revocation of the penalty, keeping in mind this aspect. However, the general manager appears to have proceeded mechanically, holding that the petitioner did not produce any document paper in support of his contention that he was sick. To expect the petitioner to produce papers of being treated by Ojha is asking for too much. Since the general manager has not considered the representation of the petitioner in the proper perspective, this court is of the considered view that ends of justice would be met if he is directed to reconsider the decision on the quantum of punishment to be inflicted in respect of the charge that has been found to have been proved against the petitioner. It is ordered accordingly. Thereafter, my lord, I am not reading, my lord, that part was set aside and said you reconsider. So, my lord, what the court held, that you reconsider it. But court did not hold that it shocks the consciousness of the court. Otherwise, the court would have said, what the court would have done, court would have set aside the order as a whole. Yes, this goes, you are reinstated, or court would have said this punishment or penalty is to be inflicted upon. But as your lordship knows, generally, court does not enter into the arena of inflicting punishment unless and until that is disproportionate and it is shocking, it shocks the consciousness of the court. Otherwise not. I will place the citations in support of my pleadings, my lord. So the court held so. Now this order, my lord, remained. this order was not appealed against. So, as this order was not appealed against, my lord, what happens, my lord? Two things. The fate of the petitioner was sealed so as to challenge
Quantum of punishment only.
Now the question only remains
You
quantum
will
of
not be
punishment,
able to
only the
reopen
proportionality.
reopen another
I
any
bow
other
down to
issue.
your lordship. I bow down to your lordship.
Okay,
Nothing
understood.
else. Nothing else. So my argument.
But you consider in terms of this order.
We considered in terms of the order.
You
This is the fourth round of litigation. This was the second round of litigation. We considered same order passed. Again, he made made a writ petition in which another order was passed, which Mr. Ghosh showed on the last occasion. It's my duty also, my lord, to indicate it to your lordship. It is at page 100 and page 88, my lord, on 7th of November 2019.
But the authority was directed to reconsider. When court direct that for this cause, I am again remitting the matter back to the authority with a direction to reconsider.
Yes.
That means the court should reconsider in the light of the observation made.
Yes. Yes.
Or the cause shown by the court to remit the matter back.
Yes. So we considered it in the light of that observation.
Yes, you so.
Okay. Now, my lord, I will come to it.
So
I will
court consider.
Now, first time, my lord, place that order of 7th of November, my lord, page 88. In consideration in page 88, where, my lord, it starts at page 88. My lord, the penultimate portion is at page 92. Court said, in view of the aforesaid, I direct the respondent authority and more particularly the Chief General Manager to reconsider the matter in terms of the order dated 29 January 2009. This order. Again, it is to be reconsidered in terms of this order and pass a reasoned order within a period of 4 weeks from date of communication of this order. It is needless to mention that the designate of the Chief General Manager or the person equivalent to the Chief General Manager will consider the matter in accordance with law in the light of the order dated 29 January 2009 and pass a reasoned order and communicate the same to the petitioner within a period of 2 weeks from the date of passing such order. Next page, my lord, the court had said in this order additionally that I am giving liberty in the event you want the back wages, you can agitate the same. So this was, but what is the pinpointer, my lord? The order of 29 January 2009. Now, my lord, I have to show why this order, the original order passed was retained. Why? Because, my lord, again, that question comes, my lord, the proportionality, disproportionate or proportionate. It comes. Now, my lord, where it talks the consents. It's not that he is to be an habitual absenteeism. It's not that. My lord, kindly think. 22 months. If your lordship kindly takes up the ultimate order, reasoned order passed by the GM. That page 95. 95. Yes. Page 95. It is the order of 13 January 2020. Now, my lord, turn to page 96. Para 2. Period of absence, my lord. Point number 8 under para 2. 1 year, 10 months, 2 days. 22 months. Kindly think. And this is not the plea of the petitioner. He was sick for 22 months. It's not in the petition. It's not the plea. Even in the order dated 29 January 2009, it is recorded. It was not the plea. So he could not establish his absence. He could not satisfy his absence for the period after that period of beyond 6/1/1993. He said, I was in the native village. I was treated by Ojhas during the period 18/9/92 6/1/1993. So it should not have been included in the charge sheet. That was the plea. Because I was treated by the Ojhas in the native village, and Ojhas manner the court also had, it's not expected Ojhas will give prescription. even
It is not uncommon.
uncommon. It is not uncommon. I take it, my lord, in law. I take it, my lord, as it has fallen from the court, my lord. Now, what about the period after 1993? He didn't say that he was sick. He didn't challenge that he didn't say, or he didn't challenge that order. He didn't say that the absence was not willful after the period of 6th January 1993 till July 1994. That's the date of issuance of the charge sheet. What about that 18 months? It comes to 18 months. Initial period, he says that I was ill, I was sick. It's for only 4 months.
You removed him from service or dismissed from service?
Dismissed. Dismissal.
Dismissed.
Dismissed from service.
Now it is a capital punishment in service jurisprudence.
Dismissed.
Forfeiting his right to be employed in another.
That is fate, and that fate will be.
And hence, in E.T. Sunup's judgment, you will read, Supreme Court was said that as and when the matter is remitted to the authority, authority remains steadfast or stuck with the previous decision.
Generally, but
it is one kind of disregard to the.
Lordship is correct, but in
so
this case,
when the court is saying that they have petitioner submit that the punishment is disproportionate, not commensurate to the gravity of the offense, and he has repentation, and that your grievances has not been considered. The court has impressed.
Yes.
The court is impressed. And the court considered that he is a person belonging to a scheduled type community, and he was treated or he was attended by one Oja, which is not uncommon. Considering this aspect, you are directed. Forget about you. Don't justify your decision. You cannot sit in appeal over the decision taken by the court.
No, cannot.
You are administrative authority. Yes. Okay. So when it is said, you are remain stuck to your previous decision. Now you are seeking justification. Now you are seeking justification, or how I shall justify my action to stick to my previous decision.
Yes.
You are not considering.
No, my lord. Here, my lord.
Okay, I am saying that, and hence the legislature has never stated that for commission of this offense, the punishment will be 7 years. Punishment will be up to 7 years. And in some of the cases, when the legislatures take stringent views, stringent stand, then the minimum punishment is given. Otherwise, no minimum punishment. In case of POPOTCO, such and such minimum punishment. That means minimum punishment means the person who awards punishment, there is a bar, a fetter that you will not go down. Minimum 10 years means if you hold that he is guilty, you have to give punishment of 10 years. At least 10 years and go up. If you go up. And every punishment from 3 years to 7 years. Why? No. The person given a discretion to choose any of the period within 3 years to 7 years. It is the discretion.
Yes.
Okay. 379 on earlier Indian Penal Code is theft. One person who is a hangry, who has theft one bread from a shop, and one industrialist, he has stolen some secret document from another company. Both are 3 years. Will be give same punishment.
It depends on the, as your lordship has said.
Same punishment.
He,
while visiting the office of another industrialist, he theft some secret document, secret of his business.
Gravity of
379. I am asking you, you are the judge.
Here, my lord.
All the board are convicted. Now
gravity of offense.
You saw clerical job, awarding of punishment, clerical job. 307, yes, 3 years. 307, 3 years. No, 0 to 3 years. And hence, the court is manned by a person who has a judicial mind. And such discretion has been given to choose any of the period in between 0 to 3 years.
Yes.
Okay. When court asking that you consider, that is the mitigating factor. While awarding punishment, you are to consider the manner in which the offense was committed in respect of, or misconduct was committed. Who is this person? What is his position in the society? Everything is to be taken into consideration.
Yes, madam. Madam, may I be permitted?
And I in my one of the judgment, I opine that we have a guideline and many Supreme Court decisions that when we are go for stricter punishment, and when we shall go for lesser punishment. There is a guideline, but no such guideline available before the authority. Some person is officiating the high post, but no available when I shall choose. And one of the judgment I stated that dismissal from service is a capital punishment. That means that circumstances and material shall be available so that the retention of this employee further in the establishment will bad for the establishment. The retention of this employee is bad, and it will harm to my institution. Then I shall remove. And there is two, whether dismissal and remove. Whether I shall go for removal or go for dismissal. Dismissal entail a further disqualification. Removal is not. That means you are choosing the highest punishment. Dismissal means you are declaring this person unfit to get a future employment also.
Yes, my lord.
Bread and butter, question of bread and butter.
My lord. Here, my lord, I would,
Yes.
my lord, like to have an example as it has come from your lordship, said for me, myself, for my satisfaction. So I will go into it, my lord. But the question, if I must say, first reply to that, but the question of bread and butter, my lord, definitely it's a question of bread and butter. If a service, if a job of a person goes, then he is without bread and butter. But at the same time, it is to be thought, my lord, there are several others who are working or are working. They are concerned with their jobs. A person, my lord, for 22 months without any explanation. My lord, delete 4 months from that. 4 months from that. 18 months. Even after ample opportunities, he could not produce anything. He could not he could not submit anything or could not explain about that 18 months. If I am a diligent person and I think about my bread and butter, my family, my son, my children, my wife, then I must be vigilant. I must be diligent. But kindly see, when the charge sheet was issued, charge sheet was issued after 22 months. We waited for him. He didn't turn back. He used to live near the colliery. Now, he said, I was sick, I went to my native village. What happened thereafter? Nothing in the writ petition, nowhere. He was to come back, he was to join. If we had not allowed him to join, he would have a purpose at that point of time, had a case. But here, it's not that. Here, he could not substantiate that 18 months. What happened, my lord? I have to bear those types of employees. It's not. And so far, my lord, as your lordship was saying about the criminal laws, my lord, as your lordship knows, I must. No, that's an example.
Criminal law is easy to understand.
Example.
Easy to understand to all. Even a common man can.
Example.
And hence, you use generally criminal law as an example.
Suppose, my lord, today I set an example for myself, for my satisfaction, my lord. In a suit, my lord, a decree is passed by the trial court. Appeal against. Appeal court says, no, this point I do not find satisfactory. So I set aside the decree and I remanded back with your direction to hear it afresh. On many occasions, my lord, it happens that the same decree remains. It goes up to the Supreme Court and it is upheld. So it's not that the higher forum says and it is to be that. What did they say? If the court would have said that it shocks my conscience, that it's disproportionate, then I had nothing to do except preferring an appeal. But it's not that. Court said, I send it back to you, you reconsider it, taking into consideration his conditions and all these things. I took into consideration his conditions and all the other factors, my lord, and I found, my lord, that there was no explanation for that for those 18 months. So keeping such a type of employee would not inure to the benefit of the concern. After all, this is also public exchequer's money. Today, for example, if I said, my lord, today he is reinstated. This person is no more, my lord. He has left for his heavenly abode.
Oh, he is no more.
No more, my lord. His heirs are substituted, my lord. They are fighting out the case, my lord. He's left for his heavenly abode. My lord, today he gets reinstatement, means he gets the back wages. Maybe or may not be. My lord, back wages also, my lord, it does not mean that it's automatic with the reinstatement, as your lordship knows. It's not automatic. It depends on several conditions and on the behavior or how he has acted upon, with all those factors. There are several factors, my lord. But suppose he gets back, my lord, but what the service he provided? Worked for 3 years, he worked for 3 years, absented. Worked for 3 years and absented for 22 months. So about 2 years, less than shorter by 2 months. So about 2 years. So that's the consideration we had taken into that's the factor we had taken into consideration while passing the last judgment, which is under challenge in this writ petition. The last order, recent order, which is under challenge in this writ petition, my lord. So, my lord.
Okay, you take me to the order.
Yes.
To show that
yes,
that you reconsider the quantum of punishment in view of the Justice Datta's order, in the light of the Justice Datta's order, that you consider such and such thing.
Kindly come to page 8, 98.
Because this order is also binding upon you.
Yes, on both the parties.
This order is also binding upon you,
yes,
on both of us. So you consider that, yes,
it is
considered that he is belong to scheduled type community,
98, my lord,
and such. You take us to that order.
My lord, may I point out one thing, my lord?
No, please. Let me finish, my lord. He will point out. He will definitely get his chance to reply, my lord. He will definitely get.
There was a remand order by 2 courts. One
that
is
I have shown.
Dotto, my lord Justice Dotto, and subsequently my lord Justice Kapoor.
Not Mr. Ghosh, Mr. Das is objecting.
I have shown that yes, there was an order of remand back and showed the 2 orders.
Yes.
I have showed the 2 orders. It's not that I have suppressed. My lord, page 98.
Page 90.
98. 98.
98. Yes, 98. Yes, 98.
Para 5, my lord.
Para 5, yes.
Prior to that, my lord, there was mentioning of the order of the Honorable Court. On perusal of the order dated 29 January 2009, it is observed that the Honorable Court nowhere questioned on the inquiry process. Rather, it has questioned on the quantum of punishment awarded to the petitioner. The Honorable Court, in its order dated 7th of November 2019, also questioned on the quantum of punishment awarded to the petitioner, both the orders. While considering the decision on the quantum of punishment, it is observed that the period of absence is more than 1 year and 10 months, which is not condonable for any reason. During the said period of absence, the petitioner did not even inform the colliery management about his sickness, whereas his native village, where he was residing, was nearest to his place of working. Had the management been informed about the sickness of the petitioner, he would have been treated better in company's hospital. But he was sitting idle in his home, and due to his lackadaisical approach, the management was compelled to terminate his service. The Honorable Court has pointed out that petitioner hails from a weaker section of the society. The undersigned do hold the same opinion, but the inquiries Unauthorized absenteeism cases is based on the documentary evidences rather on the statement of evidences. Honorable Calcutta High Court, via order dated 24/2016 in Sommaji versus CIL and others, has inter alia observed that an employee must take his duties seriously, perform his functions with honesty and sincerity, and must conduct himself in disciplined manner. An employee workman who did not think it necessary to send even one intimation to the employer during the period of absence deserves no sympathy. Further, Honorable Calcutta High Court in Dayanand Paswan versus CIL and others, wide order dated 19th May 2016, has upheld the dismissal of workmen where workmen absented without intimation. In view of the above, it is evident the period of absence is more than 1 year and 10 months. Also, the petitioner did not think it necessary to send even one intimation to the unit management. Thus, reconsidering the decision on the quantum of punishment, the undersigned is handicapped to review the punishment in absence of any specific ground, be it for sickness or otherwise. Hence, taking all factors together and analyzing
the matter in proper perspective. Next page.
The matter, my lord, not come to 19 because these are the 97 and 98 are the repetitions of the same pages.
The 99, I have got 99.
Yes, 99. There, here I got 2 extra pages.
Understand this contents to reaffirm the order of dismissal after reconsidering the
it was taken into consideration. His position, his condition, it was taken into consideration in terms of the order of 29 January 2009. Now, my lord, I have shown, my lord, this is the order, my lord. Now, so, my lord, today, my lord, I will now place some certain judgments, my lord. Today,
yes.
my lord, it's only the question of proportionality, nothing else. So I am on to it.
Yes, nothing else. Yes.
Nothing else, my lord. First, my lord, I place the judgment. State of Rajasthan versus Muhammad Ayub Naz. State of Rajasthan versus Muhammad Ayub Naz.
Yes.
2006, Volume 1, Supreme, page 37.
Para?
Now, my lord, paragraph 2349, because this 2349, why am, my lord?
2, 3, 4 and 9.
2, 3, 4, 9, 12, 13.
Fact. 9.
Fact is very, very important because more or less similar. That's why, my lord.
May I, my lord? Fact. Yes. Here also, unauthorized absence.
Unauthorized absence.
Without any intimation.
Yes.
And dismissal was?
Yes. 12, 13, 14,
punishment of dismissal. Penalty
yes.
of dismissal from service was given.
But fact, my lord, now, I, my lord, start with 9, my lord. Fact, my lord, I leave it up to your lordship, my lord, 2, 3, 4. Paragraphs 2, 3, 4. Page number 37.
Yes. So 3 years.
Yes.
3 years. And
prolonged absence.
Prolonged absence, yeah. Prolonged period. And Rajasthan also, Rajasthan service rule also incorporate a rule that if willfully absent for a period exceeding 1 month.
Here also under the model standing orders, my lord.
Yes.
That is not questioned, my lord.
So dismissal of service is the appropriate punishment.
The court held, my lord. So I will refer paragraphs 2, 3, 4, 9,
and 9,
12,
13,
14, and 18.
12, 13, 14, and 18.
12,
yes.
13, 14, and 18.
Yes, next decision. Yes.
Next decision, my lord. I will not take much of your lordship's
Yes.
time by going on reading this.
Yes.
Next decision is, my lord, it's Administrator.
Hey, Dean.
Administrator, Union Territory of Dadra and Nagar Haveli versus Gulabia M. Lad, reported in
2010,
5 SCC 775, my lord.
para
12 to 14, my lord.
12 to 14. Yes.
May I read out my lord paragraph?
Yes.
To put it differently, unless the punishment imposed by the disciplinary authority or the appellate authority shocks the conscience of the court or tribunal, there is no scope for interference. Further, to shorten litigation, it may, in exceptional and rare cases, impose appropriate punishment by recording cogent reasons in support thereof. In the normal course, if the punishment imposed is shockingly disproportionate, it would be appropriate to direct the disciplinary authority or the appellate authority to reconsider the penalty imposed. In the case at hand, the High Court did not record any reason as to how and why it found the punishment shockingly disproportionate. Here, my lord, court didn't record that it is disproportionate, shockingly disproportionate. The order of 29 January does not record so. Even there is no discussion on this aspect. The only discernible reason was the punishment awarded in M.L. Keshwani case, as was observed by this court in Balbir Chand versus Food Corporation of India Limited. Even if a co-delinquent is given lesser punishment, it cannot be a ground for interference. Even such a plea was not available to be given credence, as the allegations were contextually different.
Yes.
Now, in Union of India versus SS Aluwadia, this court reiterated the legal position as follows. The scope of judicial review in the matter of imposition of penalty as a result of disciplinary proceedings, all this, and then, my lord, 12, 13 and 14.
Punishment is just your discretion. Discretion of the
and my lord, only where it is
shockingly
disproportionate. It shocks
then
the
only
conscience
court
of the
can interfere.
Yes,
There
my
is
lord.
no.
Next, my lord, is Deputy Commissioner KVS and others versus J. Hussain, reported in 2014, 4 WBLR, Supreme Court 635.
Yes, para
6, 9, 10, 11, and 12.
Yes.
6, 9, 10, 11, and 12.
Yes, disciplinary authorities to decide particular
Yes.
Limited scope, shockingly disproportionate.
Again, well, that's the same thing. And the most important one is, my lord, in 2014 4 WBLR SC 635.
Yes.
Yes. And the last one, my lord, it's your lordship knows it very well, my lord, that's the P. Gunashekaran case. That's the Union of India and others versus P. Gunashekaran, Likhana of 2015, volume 2, SCC 610. Here, my lord, the facts are German, facts are very important. The facts, my lord, paragraphs 2 to 10. And hereafter, my lord, and the principles, my lord, 12, 13, 19, and 20 to 25.
Yes.
13, 19,
That
20,
is
21, 22, 23, 24,
P.
25.
Gunasaran, yes.
Yes.
Gunashekaran,
It also says,
yes.
it was also dealing with the same and
same proposition. Yes.
same proposition, my lord. So here, my lord, my submission today before your lordship is this. After the order of 29th January, where the court did not hold that it has shocked the conscience of the court, but only sent it back, directing the authority to reconsider the same, keeping in view the society of the petitioner, the class of the petitioner, society of the petitioner, keeping in view. Otherwise, the court held everything is correct. There is no infirmity in the charge sheet. There is no infirmity in the inquiry proceedings. So nothing remains thereafter, save and except disproportionality. So we passed an order first on that basis, which was again challenged, my lord, and was set aside by the subsequent order in 2019, on 7th of November 2019. And by 7th of November 2019, the court again directed us to reconsider the same. There also, my lord, did not record that it shocks the conscience of the court. There also, my lord, in the order of 7th of November 2019, my lord, the court said you consider it in the light of the order passed on 29 January 2009. So again, we passed that order, my lord. That order I have read out before your lordship, and challenging which this writ petition is passed. So my submission is this, my lord.
Anything is reply, Mr. Ghosh?
I think he will be requiring another day, my lord, for going through the judgments.
No, yeah, where judgment? All are settled principle. You have not given any new.
No, not at all.
Service jurisprudence in disciplinary proceedings matter. This is the settled principle.
Yes.
Yeah. Mr. Ghosh.
Or one thing, my lord, I do not require, because as your lordship has already held, that everything is settled there by that order, because I wanted to show that my epidemiological AR, where they have not denied that, yes, if there is no infirmity, all these things, because your lordship has already held. So it's all.
On next day, my lord, we will reply.
No, you asked you, how many days? One matter hearing is 3 days. 3 days, then why?
Only for 5 minutes, my lord, if your lordship kindly fix it. For 5 minutes.
5 minutes.
We are facing some difficulty, my lord.
Oh.
For 5 minutes only.
You go on making submission. You are audible, don't worry.
No, for 5 minutes only, my lord.
And hence,
because I have to distinguish the judgment as has been.
Yes. This all are settled principle. All are settled principle. He submits. His main submission argument is that the court has never held that the charges is bad, or initiation of the proceedings is bad, or the decision making process was bad. But he submits that the court remanded the matter or remitted the matter back to the authority with a direction to reconsider the quantum of punishment. The authority stuck to his previous decision that in case of unauthorized absence of
22 months
cannot be condemnable.
And of which 18 months is at all without any explanation.
Yes, the petitioner's
let him show an explanation.
Residence is near to the place of work.
Yes.
He could have sent one intimation also. He has not sent it. So here, dismissal is the appropriate punishment.
At least for 18 months, no explanation. Let him show there is explanation.
Penology is a subject which is not static. It is evolving. Why we punish? There are many theories, retributive, deterrent, that so deter this accused person and others from committing such thing. Yes. To create an example. Look, if you commit this offense, you will be punished in this way.
So that it may not go viral.
In this way. Lastly, it is evolving.
No, otherwise, my lord, why the punishment?
No principle and nothing in the law can be remain to be static.
No.
Every day it is a subject which is going on.
Yes.
It is not a subject which is
dynamic always.
The principle which as on date we have got, it will remain.
We have learned.
We are evolving.
Yes, we have learned.
Yes. And we have to go on learning.
Always dynamic.
Now reformation theory has come.
Yes.
Now reformation theory. However, one balance sheet is required to be
It is not called jail. It's a reformatory home.
Whether this person will reform or not.
Yes.
Whether there is a possibility of his reformation or not.
Yes.
Yes, this person is habitual absentee. Whether there is a possibility of reformation of this person or not.
What happens there, my lord?
Or this person has committed this offense.
Some persons, my lord, in habitual absenteeism, suppose, my lord, there are 40 days. So he remains absent for 30 days. And that's 3 years, either consecutive or not, 3 years. Some persons like this, these are different sets of, my lord, things are done. Some, my lord, continuously for 22 months, 3 years. I have shown, my lord, that one 3 years. So court said that all these things are to be taken into factor. But it's not that only if you are a habitual absentee, then only major penalty will be imposed. It's not that.
Yes, Mr. Ghosh.
Sir, if you lordship penalty fixed for another day, my lord.
Yes.
If you lordship penalty fixed for another day, my lord. Actually, I am a little bit out of station, my lord. This is the difficulty, my lord.
Problem. If court is to give go on
My lord,
time.
if you lordship allow me, my lord, kindly then, my lord, make it possible for 10 minutes, my lord. I am, my lord, coming back then, my lord.
Another day. Yes, Mr. Das Lanet advocate representing the petitioner have
Not
concluded
petitioner,
has
respondent.
respondent has concluded its submission, and accommodation has been sought for on behalf of the petitioner. In view thereof, stop the list the matter for further consideration or
My lord, tomorrow it can be taken up at 2 p.m. Why, my lord? Mr. Ghosh and me, we have that another matter fixed at 2 p.m. Original side
Very
matter.
well, very well, my lord. Very well, my lord. I am ready. I am ready, my lord.
Why I am fixing it?
So, my lord,
দেখুন তো একটা ডেট দেখুন না, একটা ডেট দেখুন, একটা 2 p.m. একটা ডেট দিয়ে দিন। Today most probably it is the first matter or second matter?
First matter, my lord.
After two.
First matter.
না না, আজকে কি নিলাম, দুটোর পর কি বিজনেস করলাম, ওই ওটার এটা তাহলে 1 hour এদিকে।
If 5 minutes, my lord, tomorrow, if you
court is to give 3 hours to a matter on 3 different days, how the matter will be disposed of?
So, my lord, if your lordship keeps it tomorrow, my lord, tomorrow we have the matter.
যে কোনো একটা সেকেন্ড 2 p.m. করে দিন না। তার আগে আগস্টে 25, 26, 27 আচ্ছা, on 2nd September, on 7th September to be taken at 2 p.m.
That will do this.
So you consider,
well, I have nothing.
1 hour.
No, otherwise it could have been taken, my lord. It can be taken up.
If petitioner take 1 hour, if the
my lord, tomorrow, my lord.
If the respondent take 1 hour.
Well, I will take 5 minutes, my lord.
So in first half we have 3.5 hours. Only 2 matters, hearing matters will be taken up. In second half, 2 hearing matters. So 4 matters only per day.
No.
4 matters, echo.
Well, I have tried to shorten my, I didn't enter into other areas, my lord. That's why.
Yes, next.
Get, my lord.
156.
Next.
Can be done. 156.
My lord, in this matter, Mr. Rai has been appearing. He was waiting for the matter to be taken up, but currently he's on his legs in court 11, my lord. Could it be made not today, my lord, or passed over? If it could be grateful, my lord.
Yes, তাহলে এটা আপনি যেদিন ফাঁকা থাকবে সেদিন দিয়ে দেবেন 2 p.m. আর নাহলে ওগুলো কি করছেন, স্পেশাল কি
Item number 16.
16, yes. দেখুন আবার পিটিশনার আছে, রেসপন্ডেন্ট আছে, রেসপন্ডেন্ট
I'm the respondent.
Yes.
I file a supplementary affidavit in the last occasion with your lordship leave.
Yes.
These are all licensed distilleries, distributors. Okay. Those manufacturers are asked to stop. Distributors are asked to stop. Just warehouse they distribute. Stop. And government itself wants to take the entire business of those all distributors. Kindly come to the supplementary affidavit, page 5.
Supplementary affidavit. Yes.
Exercise of power conferred under page 5. Section 85, section 86, to exercise that this amendment has been effected. Your Lordship did not travel to the entity, kindly come to 3.
Yes.
In the said rules, Rule 23 shall be inserted. 23. Private warehouse for the deposits and storage of foreign liquor license not to be renewed. There are numbers of warehouse who used to store foreign liquor that has been sought to be stopped. But the government thought it fit, they constituted a corporation. Corporation will take the entire business. So it is not possible for the government to overnight make the infrastructure, the manpower, everything to proceed with this warehousing business. I am inserting the word in the council to give them part, those persons whose salary, workmanship, service has been stopped overnight, to be given employment in corporation. All the persons who are dealing with these activities was experienced, they was asked to and corporation. They started work. All of a sudden, when the question comes in for regularization of these people, and what is the regularization? Not permanent regularization. They will be only retiring at the age of 60 and they will get the benefit of that, sir. Not the permanent employees taking the earlier benefit. No, not. On the basis of this, what they did, they excluded these petitioners from the arena of, I am using the word absorption, in the manner, 60 only, nothing else. They were excluded. Giving a go by that, they are not properly qualified. That prompted us to approach your Lordship. First of all, let us come to the order issue. When we are defining for this our assumption, in the report, they disclose the document, which is now my subject matter of challenge. And we got to get at this art which can I take the reply?
Yes.
They have handed. After this, I will go to the circulars which by which we are governed. Now, what is the stand of the government? 19 September 2022, page R3, page 12, page 12.
Page 12 of affidavit in reply.
No, it's not a report.
Report. Yes, report, yes. Yes. Yes.
And this is subject. Extremely satisfactory to the contractually engaged and personnel as per the first document process. Understand the directive. Clarify the following. The requisite qualification for data entry operators as depicted in memo number suggestion is stated as graduation with certificate in computer application. Whereas out of 192 for data entry operator, for its corporation, if it is 100 of candidates are undergraduate, and moreover, out of 100 of candidates, 12 candidates are under 10 standard, and moreover, other candidates may be more technical.
Yes.
Which the repetition was generally for our observation. In response to that, this is the subject matter we are going to right? The facts and certificates. But for the repetition was who? Justice. Kindly, the order dated 22nd August 2023 in Lordship. The order seems
22nd August.
22nd August.
Yes.
Internet for vertical artificial operation, and global support service provider. Under the University Device Application Undertaking 6 October 16, contractually engaged IT partner can be pretty of engagement up to the age of 60 years. They are not calculated except about the stage. They will also clearly be given one-time terminal benefit of contract or action. Process of of this. However, despite meeting the qualification, such benefits have not been part of the whereas some of the other data is operators similarly placed like the liability of the council qualification as indicated in the paper but not extended. Considering the other submission of parties and report is of the view that justice will be served by directing stating why the prisoner have not been given the benefit of memo number 16 October 2020. These two memos are not. Kindly come to page 140 of the document.
Yes.
Whereas the government of Calcutta has in the last few years part of the government computerization of interest transfer of government in order to achieve this governments are using 5% data in the government. Even or WI or similar agencies, while some engagements have been made directly by or the terms and conditions of service also vary by across the department. There is a number of sites and what? What is the criteria? Direct payment from the government installment and for but engage through WDL, WDL or any person comes under the direct control. Criteria, if I am engaged WDL, I will create the link.
Yes.
This circular suggests that if I am engaged to WDL, I am entitled to have this benefit. I was engaged, I was not doing it. He was completely. In my lord, now come to 4, 19 September 2020. They have relied on this. That's why I have told you, can you keep it side by side? Here concern is not applicable.
So the requisite qualification as stated in the memo dated 27th July 2013 is not applicable to you, according to you. Yes, certainly.
It will come from the court, according to the court. This is
No, according to you, yes.
why I am saying I have to give the explanation why. These are the criteria laid out for direct absorption, which all benefits. We are not. I have shown to Lordship what is the protection? 60 years of age, that's all. And 1 lakh retirement benefit. The regular establishment, regular employees having much more benefits. This probably this circular has been laid out only on the wrong impression that we are asking for regularization. If I am getting the regularization, then my benefit is much more higher, which we are not entitled. I am saying I am not entitled. That's why you have not asked for it.
Yes.
I come to the again to the report.
Report, yes.
Report. Page 16 kindly come. Item number 3. Come to 12.
Yes.
Yes, Sarkar. Is graduate. Why is it true, sir? If this circular is applicable, that you are not graduate. Factually, it is incorrect. Question number 12, validity of what? Yes, Hussain Sarkar. Saddam Hussain Sarkar. Is graduate. Is computer degree or not? He is also. 31. Graduate.
31 serial number.
51.
Yes.
Salam is graduate with diploma. And finally come to 56. Das graduate with diploma. 8. Graduate with diploma. Read petitioner are
So all the repetition are graduate. Are graduate.
even if this applies, even if this applies, I say it's not a if it is not that, I'm not talking about others. They are graduate and having diploma. And through WTL, they are appointed. The voluntarily they are not appointed. Criteria is to be appointed either by Webel or by WTL. All were appointed. There is no dispute about that. Now, I started with the submission, that is a scheme. Otherwise, those persons will be overnight knowledgeable. For that purpose, they are engaged. They may not tell the consumer situation. The corporation established in the year 2017. Till it is running. There is no private warehouses there. Who are running this show? Who are running the show? These persons who were engaged in the private sector, which was directed to be closed down, they were brought in. So it can be said it is a scheme for which these persons was certificate taken for running this show. This is a welfare state. You are taking for your benefit. Working, there is no allegation against me up till that I am not performing my duties properly. And one fine morning you will say, no, you are not eligible, that you are not qualified. From the, your lordship will see what is the job. Job will not see my reply.
There is a data entry operator.
Data entry.
Data entry operator, yes. So data entry job.
Actually reply.
Yes.
Reply. This is how the beverage corporation formed. Kindly turn over the page to page 16. Or for your lordship to forming a idea why it was formed, how it was formed, who is running. So can you give this governance also? Following decision of the government shifting. Following decision of the government of Gujarat during early 2017, it covered the entire wholesale business of packaged liquor in the state from the private sector to the wholesale state beverage corporation. The company formed under the finance department, government of Gujarat. The entire process flow of this corporation dealing with the liquor mart with an annual turnover of around 1,500 crores has been
has been automated under the
Finding fault on mine that I cannot read 15,000 crores. I cannot read 1 crore. How can I read 15,000 crores?
yes, 15,000 crore, yes.
Has been automated.
Hmm.
Under the e-beverage package, registered suppliers price sales offered to the corporation legally and supply stocks to the corporation because against order of supply which is through our electronics. Yes, and retailers for their supply stocks over the e. So entire process is on electronic basis. We are the person who is the data entry operator. We are the soul of this business. Then ecosystem is organized and functioning with supply management policy function reports life accounts management finance and accounts among others. This job we used to perform in the private sector. That's why they took us. Now can you see what is the job? Can you come to page 18?
Yes.
There is data entry operator stroke node assistant. Here, is in manner it is written, it says or, but here we do both the work and it should be read as an and. CPU stroke and proper hacking as per batch number, brand name, device, offer routine regularly assessing all are electronic process. So what job we were doing in the private sector, we are taking for that and we are doing the same job. I was asking the question was, in spite of this, why we will not get that benefit? Only the protection of service, not the absorption. There is distinction between two. And now the report says that you are not graduate and not qualified. So you are excluded. I have told you that the repetitors are all graduate and all are having the diploma and doing the same job of data entry operator.
Okay.
Implemented, the burden would be on them 7,000 rupees, nothing else.
So that's all. Mr. Mukherjee, so your main reason for refusing to grant such benefit is that they are undergraduate?
They are a different category altogether. I shall show my lord.
That
From
is
the
petition.
IT professional. Yes.
We are concerned with the writ petitioner only.
Yes.
Yes.
My lord, your lordship kindly consider page 76 first. My lord, this is a notification dated 22nd July 2013.
Yes.
My lord, kindly consider the subject. Engagement of software personnel in the e-governance project on temporary basis.
Yes.
Now, kindly consider clause 8 of page 76.
Yes.
Selection of manpower shall be done by a selection committee comprising of at least 3 officers, of whom 1 representative should be from NIC or IT department and 1 representative from concerned department or directorate. Now, that means, my lord, although this was for the contractual employees, my lord, but there was a selection committee. And kindly consider this first paragraph. Most of the departments, directorates, or offices of the state government are now implementing different types of e-governance project. So these, my lord, personnels, IT personnels were, my lord, appointed for, my lord, this e-governance projects, my lord. Now, your lordship, kindly consider page 77, my lord. My lord, clause 14, my lord, professional fee remuneration of the software personnel. My lord, the first box, your lordship, kindly consider data entry operator, then minimum qualification and experience that was prescribed, graduation with certificate in computer applications, my lord. Then, my lord, at the right hand side, my lord, your lordship, kindly see the consolidated professional fee for per month was 11,000 for freshers, my lord. Kindly consider this. Now, my lord, your lordship, kindly turn to page 59, my lord. My lord, this is dated 6, I'm sorry, my page 59, my lord, my learned senior friend, my lord, has placed page 140, same, my lord. Page 59, this is dated 16th October 2020. My lord, the last paragraph, now therefore, in view.
Yes.
My your lordship can consider page 140 or 59. Same notice.
Yes, you read whatever.
Now, therefore, in view of the critical role played by this contractually engaged IT personnel in the continuing success of e-governance reforms, their service conditions have been reviewed. It has been felt that the present terms and conditions of their engagement need to be improved upon to retain the best talent in such and such. The state government has decided to make the following changes in the terms and conditions of the engagement of IT personnel engaged under regular establishment and in different program project, whether engaged such and such. Then, my lord, your lordship will find that some benefits were given, like benefits to be extended, security of tenure, then leave, etc. Terminal benefit of rupees 3 lakhs, my lord, that at page 60. Now, the petitioner, they are seeking this benefit. Now, they made a representation at page 62. Then, they have annexed a chart indicating that they are qualified personnel within the meaning of this page 76, that is memo dated 22nd July 2013. Now, BEVCO, my lord, the corporation, my lord, referred the issue of all the personnels of this data entry operator. They are called floor assistant come data entry operator. They were appointed sometime in 2017, 2018. Initially for 3 years, then the term of engagement was extended, my lord. Now, my lord, they are all, my lord, the floor assistant come data entry operator of BEVCO, my lord.
Yes.
Now, my lord, they referred, there are 190 personnel. The BEVCO, my lord, referred the entire issue to the finance department. Finance department, my lord, issued this order at page 75.
Yes.
From Deputy Secretary Technical to the Government of West Bengal Finance Department. Extending service benefits to the contractually engaged IT personnel as per such and such department notification dated 16th October 2020. That is page 59. With reference to this office on the subject mentioned above, the undersigned is directed to request him to clarify the following. Kindly mark this phrase. To clarify the following. The requisite qualification for data entry operator as depicted in memo number such and such dated 22nd July 2013, which is at page 76, is stated as graduation with certificate in computer application, whereas out of 192 floor assisting on data entry operator under West Bengal State Beverages Corporation, that is BEVCO, 101 candidates are undergraduate, and moreover, out of 101 candidates, 12 candidates are under 10th standard, and moreover, all the candidates are having no technical qualification. Kindly see the prayer now. Prayer of the writ petition. Page 7, the prayer is at page
24.
Yes, 24. What is the principal prayer, my lord? Read in the nature of such and such. Produce all the relevant records such and such. Inaction and memorandum dated 9, this should be, my lord, 22, 19 September 2022. being annexed P5, such and such, maybe washing off the same. Washing off page 75. Now, this is only a clarification which was sought, my lord, from the finance department and whether they are fulfilling the qualification or not. This is not a final decision, and BEFCO thereafter has not made any correspondence. Therefore, my lord, this cannot be termed as arbitrary. This is only a clarification whether they are fulfilling the qualification or other criteria or not. This is not a final decision. Now, what is the second? Therefore, my lord, this is premature, my lord. My respectful submission is, my lord, that the issue has not been decided by the state. State has not said that I will not extend this benefit. But only, my lord, clarification was sought for, which has not been given. Till date, my lord, I do not think BEFCO has been served. I think BEFCO is not. Yes. But it is the BEFCO, my lord, who will come and, my lord, apprise your lordship whether they have given any, my lord, reply to this or not.
Your BEFCO has, as you stated, has referred the issue to the finance department.
And finance
you are representing the finance department.
Yes.
So the stand of the finance department, you kindly disclose.
Yes, I'm
what
coming to
is
that.
your stand?
The first thing is, my lord, your lordship will find from the page 75 that they failed to meet the educational qualification. This is one, this has been indicated.
Two educational qualifications.
Yes. One
is graduate.
Graduate.
Another is knowledge in computer application.
Yes.
I have been informed by the petitioner that all the petitioner graduate,
only 14,
and all are diploma holders.
Only 14 out of 190.
I have stated that court is not concerned with the non-graduate. Court is on any other person who is not petitioner before the court. Court is concerned with the petitioner only. The writ petitioners are all graduate. As I have been told, I have not checked. You are here to check. I have been told writ petitioners are all graduate and all diploma holder. Now all graduate, it is admitted position, he has said. Now they are saying that diploma holder.
Yes.
And
Graduation.
you have used with certificate in computer application.
True.
So the certificate holder in computer application or diploma holder, what they are saying, are same equivalent or not?
Yes. Now, my lord, in order to, my lord, claim the benefit, my lord, as my lord contained in the notification dated 16th October 2020, my lord, it has to be substantiated, my lord, that, my lord, they are fulfilling all the criteria. Your lordship, kindly consider page 76 once.
Yes.
Clause 8, my lord, I have shown that there was a selection committee for the IT personnel. Now, all these petitioners, the 14 before your lordship, or, my lord, all the 190 employees who are, my lord, engaged in BEFCO, they, my lord, there was no selection committee for them. They were simply appointed. The names were sent by the Webel. They were simply appointed.
Mr. Rai Mukherjee, it is coming from the bar.
No.
It is not in the report,
My lord,
not in the affidavit in opposition.
I can clarify.
Maninder Singh Gill, you are very much aware
My lord, in my report,
that unless you raise this issue in any of these document or in the because you cannot take it even in your affidavit.
My lord, in my report, my lord, it should be there, my lord. I shall indicate that. Your
Yes.
lordship, kindly
Yes,
consider.
indicate.
Yes.
Why? That they were absorbed or they were.
No, they were appointed. But
Whether
in what manner? They have not faced any selection process.
Don't insult the word appointment. They are engaged.
Engaged, yes, engaged.
They are engaged.
Now, for them, my lord,
11,000 is not appointment. Don't use the appointment.
now there is another, my lord, kindly consider there is another distinction. Page 77 for the IT personnel, the salary, the remuneration was 11,000. Kindly consider.
Okay, one thing, Mr. Rai Mukherjee, I say that the person who was absorbed, engaged, or appointed according to you through a selection process will only be given the benefit of such circular. You show.
my lord, that then I have to file another affidavit, my lord. But question is, my lord, one must show that they are similarly circumstanced. The nature of job is different.
As and when court asks any clarification or question, then you say that give me another chance to file another report.
My lord, I can produce all records, my lord. If your lordship ask me to produce records, I can produce all records. But there are three major my lord, differences. My lord. The first difference is the nature of job. The nature of job is, my lord, this is, my lord, inventory. They are engaged basically in inventory management, loading, uploading of these liquor bottles, etc. The second major difference is, my lord, kindly consider page 77. The salary was 11,000 for IT personnel. Kindly consider their salary, much more than this. They are saying, my lord, that benefit should be extended, but they are, my lord, your lordship will find from their appointment letter, they are, my lord, are a different category altogether. Kindly consider their appointment letter, which is at page 43. Kindly see their basic pay, page 43. It should have been 11,000 in terms of page 77. Kindly see their basic pay was 12,825. So IT personnel, my lord, they used to receive 11,000. Their scale was 12,825. Kindly, my lord, compare page 43 with page 77. And this benefit, EPF, etc., these were not extended to the IT personnel. My lord.
11, the rate was 11,000 in 2013. We are about 2018. 1,000 dinner.
This 11,000, my lord, is one lump sum, my lord. This bonus, cross pay, EPF, etc. These benefits were not extended to this IT personnel, my lord. This is my instruction, my lord. There was, my lord, this pay differences are always there. Now, lastly, my lord, your lordship will find this qualification, my lord, page 77. Now, admittedly, these 14 persons out of 190, my lord, they have fulfilled this qualification.
Yes.
Now, my lord, if your lordship extend this benefit, my lord, contained in page 59, my lord, then, my lord, subject to your lordship's kind correction, my lord, kindly correct me, my lord, if I am wrong. My lord, this will create another kind of discrimination because the rest of the employees, my lord, who are engaged in BEVCO, they will discharge the same duties, but they will get a different pay scale. And this will create another kind of discrimination amongst the employees of BEVCO on the basis of their qualification. Because out of 190, my lord, there is only, except this 14, my lord, they fail to fulfill this qualification. Then they will come and say that we are, my lord, identically placed, we are discharging same duties, therefore kindly extend this benefit to us also.
Okay.
And these are my thoughts.
The petitioners who are currently working as a data, who was previously working, who were previously এই কি দিচ্ছে দেখুন তো, আচ্ছা
উঠতে পারে